1, 2, 3, and 4, we are reserving it. I've started passing the order, but I couldn't complete it. So there were another 13, 14 matters which is to be delivered today. Reserve, we'll pass it after the Bihu vacations. 1, 2, 3, 4. Huh? 30 parties at length. Hearing concluded. Judgment reserved. Yes. Yes. Where is the records?
Records, my lord, probably Mr. Mehdi placed before this. Where is record?
We'll take it up after that. Yes, Mr. Sharma.
Lordship, if it is allowed, Your Lordship, this matter may be taken up after the vacation.
Why?
Because the original document is not with me. And this matter was looking after by some other advocate earlier. A matter of 2016.
Where is Mr. Botagu?
Yeah, my lord. This case will be, I will argue, Lordship.
You will. Okay. What is
Yes,
your
my lord.
ground here?
Mr. My lord, I am also not prepared, my lord.
Oh.
So after vacation, if possible, I will be prepared, Lordship.
Okay. On the prayer of the learned council for the parties, raised to list this matter again on Mangalbar, no?
Yes,
29, 1, 2026.
Deeply blessed.
Your Lordship, can it be bit before, Your Lordship, or that bit afterward?
Huh?
Bit before or afterward, Your Lordship? Because it's a month end, so I have to make a report of all the
After going to
On 3rd, 3-2.
highly
Yes.
obsessed.
highly blessed.
None appears for the petition on call. On the last date of listing also, there was no representation on behalf, last date of listing, that is on 22/5/2025, there was no representation on behalf of the petitioners. So, he's not a graduate, so he's retired also. Accordingly, petition stands dismissed on account of due to non-prosecution.
Pilot 8, we are for the respondent, Oil India.
The council has shifted sides.
Yes.
Petitioner council.
Pilot,
The only
Yes.
thing is, I think I heard this matter once.
once.
Oh, I have read it. I don't know. Because it looks very familiar. They are covered by the VDP. And they cannot demand a scale of pay or something in that from the oil.
Exactly.
You are appearing for whom?
Oil India. The issue was linked with Rule 10.
10.
The Rule 10 was at one point of time under challenge before the Honorable Division.
That was upheld. That
no,
was
that was withdrawn.
withdrawn.
Now that there is no challenge to the rule. Huh? Now that there is no challenge to the rule. So in the face of Rule 10, how far this plea can be maintained?
But given the fact that the council has sides,
Yes.
I think I'll not dismiss it today. We'll keep it for after Bihus.
After Bill.
Good for you also. None
Provide
appears for the petitioner on call. Mr. S. Dr. Learned Senior Counsel, assisted by Mr. K. Kulita, Learned Counsel, appears for the Oil India,
Oil
India respondents. However, the petitioners are given a further chance to make their submissions in the matter. Accordingly, registry to list this matter again on 27th
27th January.
date,
Well, can it be on 5th of February? In fact,
5 to 22. Hey, yeah, bro. Yes, madam, why did you put unnecessary tick marks in the verification rule?
Lordship.
Now you are in trouble.
The matter may be passed over for time being your.
Time being, okay. You're there.
Oblige your lordship.
Item number 9, Lordship.
9, I've kept it pending because petitioner council is.
Lordship, Lordship.
My lord, I am for the petitioner. Your lordship may kindly permit me to go a little bit slow. The file is somehow misplaced.
Oh,
Well, it's coming, my lord. I'm just
okay, after some time we'll take it. Bank employee,
bank employee. My lord, my
your case is that the charge itself is not permissible to be given. So we'll have to examine that.
and my submissions are basically twofold. First of all, the allegations which they have brought, these do not form misconduct.
Misconduct.
Number one. Even if it is
But
assumed,
Mr. Doctor, misconduct is like a rubber band. Huh?
no, my lord, therefore, my endeavor will be to my lord,
Interesting.
demonstrate before your lordship.
You make your submissions.
My lord, just 2-3 minutes. my
Oh,
lord,
it's
coming.
okay. You take your time. When you are ready, just let me know.
Yes.
Yes, Mr. Nayak. Mr. Nayak, you are there. You are there. Pension recovery. Why with this? What is he? He's a
My lord, the first thing is that my lord, this petitioner for the last 3 occasions he is not appearing before this court.
poor man, retired person for the fault of the advocate. Why should we?
My lord,
What do you have to say?
he is an assistant engineer, my lord. He was
Assistant engineer.
yes. Synopsis, my lord. The writ petitioner at the time of retirement was working as assistant engineer in the office of the respondent number 6. He is an officer, my lord. He is not a grade C or grade D. And my lord, in service book, how his 1 year, that date of birth, my lord, he only supplied it. We, after verification of his,
He did not join as an engineer.
but he retired, my lord, he was working during, while he was
It's
retiring.
different thing. He might be a junior subordinate engineer somewhere.
No, my lord, here it is written, my lord, that in synopsis, my lord, you will find, my lord, third line, my lord. The writ petition at the time of retirement was working as assistant engineer in the office of the respondent number 6.
So what do you say?
First thing is that, my lord, my contention will be, my lord, on the last 3 occasions, the petitioner counsel is not appearing. The court has taken a note of it. Last 3 different dates.
Okay, we'll take it up in the second round.
I think he will not appear, Lordship. Lordship will take about.
For my satisfaction,
His lordship.
and I don't want to dismiss this petition.
Lordship will dismiss on the next day, Lordship.
No, today it's there. But second half, let's see if he comes.
Lordship matter may be passed over for the time being.
Time being, okay, we'll pass it over. Where is the learned counsel for the?
Lordship, my senior legs in court number 15.
Oh, that. Time being. Yes. Have you passed any order?
No, my lords.
Why?
No, what I would humbly submit is that let there be an order. Let him file a representation because there is no representation filed till now. That was in fact, the suggestion that I had made on the last occasion also, my lord. Mr. Dr. Sharma was not agreeable. I think he wanted full salary from here only. But I think, my lord, in the circumstance of the case, that would be the proper, my lords.
Where is that 48.2? That regulations,
48, the regulation.
which says that you have to pass an order.
But at this moment, I do not have the hard copy.
You can get it. Let Mr. Sharma also come. Today,
But-
maybe because of the weather, people are not coming.
Perhaps your lordship may list it tomorrow, if possible. Some difficulty today.
None appears for the petitioner on call. Mr. A. Ganguly, Learned Counsel, appearing for the respondent bank, is present. For the ends of justice, registry to list this matter again on Thursday.
Lordship.
What is happening today? Have we sat earlier? No, we have sat on time only. Another 2 minutes late. Like it.
I am otherwise ready with
Yeah,
11.
let me just run through the
Yes,
file. I'll come back to you. So that we are freely to
Yes,
hear you, ma'am.
Yes.
Yes. Have you, Mr. Mehdi, have you gone through the records?
Yes.
What is there? Your case is basically, Mr. Chakraborty, no PO,
No PO,
cross-examination not permitted,
not permitted.
and the ER inquiry report was not given to you.
And my lord, that.
And the appeal was dismissed, will not be considered. That note was given by the disciplinary authority himself.
And then, my lord, that the order that has been filed by the disciplinary authority, you kindly see that is absolutely unspeaking order, my lord. And recording irrelevant things, my lord. Page 27.
Huh.
That last occasion, lordship, permitted me to
Give me some judgment.
on IO cannot act as PO, my lord.
Is judgment required for that? You can give me. You have spent time getting.
one I'm giving.
Why will I not get it?
This is considered all judgment, my lord.
The charge against you is not basically unauthorized absence.
Yes, my lord. Basically, unauthorized, my lord. And my lord,
That pilot duty.
having gone through the record, lordship was last time because I have not seen anything. The explanation given and that punishment which has been imposed, that was harsh in nature, your lordship. Going through the record, lordship,
We wanted, I think, to make it without cumulative effect.
my bad. That was too harsh, your lordship pointed out that.
That you will also agree?
That I agree, but the procedural part, your lordship, kindly see.
But
totally
the
vacated.
charge against you, being a disciplined member of a disciplined force, that cannot be ignored. Okay, let us have here Mr. Talukdar. Yes, Mr. Talukdar. Why was the inquiry report not given to him? Or let us go from first point. Why no PO was appointed?
Procedural lapses, lordship, I'll face the record, lordship will find it.
You just give me an idea so that it's effective for me to look into. With regard to the PO, there is no PO appointed. Okay. With regard to the cross-examination part,
Cross-examination or kiya sir?
is it written somewhere that he had declined that? Then we can get hold of Mr. Chakraborty. Have you gone through the records?
No, that, yes. I asked for your lordship, said that that cannot be permitted now. So I for the inquiry report, my lord.
Lordship may grant me some time, after some time I'll is the record.
And list of document was also not given. I am not sure, my lord, from the inquiry report, whether any document has been relied upon also. That I could not go through, my lord.
Because the inquiry report is not on record because it's there only.
My lord.
Last time, I think I went through that.
Yes, my lord, that's why. Your lordship
Every
gone through the
photocopy was
inquiry report.
produced before your lordship.
Copy was given to your lordship.
Hey, Mr. Chakravarti, you go through it.
My lord.
Yeah. You learn it. I'm me. Yes, where are the judgments?
May I please, your lordship? Lordship, my senior counsel is at Sessions Court. Kindly matter may
Huh?
be taken up at Sessions Court, English Council. Matter may be taken up after.
After some time.
No,
Madam, we
obliged,
have
Lord.
heard him. We have heard you. Only thing he wanted to produce some judgments.
Yes, Lord.
That much only. We'll see. We'll dispose it.
Obliged.
Yes, madam.
Please, your lordship. Lordship, my senior is on legs in another court. This matter may be taken after some day.
At least he is here. Okay, fine. Others are not here.
May it please your lordship.
Ah.
On the last occasion, the matter was heard at length, lordship.
Hmm.
No inquiry report submitted, lordship. And neither the petitioner was called
Yes,
for
where
inquiry,
is Mr. Sikes Burwa?
which is clearly reflected in the last order, lordship, 17/12/2025, lordship.
On the way. Very cold outside, so we'll give them some more time.
After
After
some time,
some-
lordship.
Yes, Mr. Monto.
Item number 21.
21, 20.
21 and 22, my
Hmm.
lord. My lord, I am being deprived because of my promotion. Already I am being retired.
Hmm.
So, my lord, your lordship kindly see, at the time of my lord consideration,
Hmm.
when the DPC was held, my lord, there is nothing. No, my lord, DP is pending against me. No, my lord, criminal charge sheet has been pending against me. But my case was not considered.
Hmm.
Even then, my lord, thereafter they proceed with my lord inquiry. Inquiry, my lord, and first inquiry, it was first inquiry, my lord,
Your case was considered for promotion.
not
Seal cover.
still cover. But that I presume.
Hmm.
I don't know, my lord, they have not been stated anything.
Because they have not filed an affidavit.
Affidavit. Then what happened, my lord? Inquiry was conducted. In inquiry, I was exonerated, my lord. It was not been proved against me. Then, my lord, de novo they have instituted.
When was your case considered for promotion?
First, it was my best mate was, my lord, promoted in 13/4/20. No, that is, my lord. First, DP initiated against the petitioner. DPC was held on 16/2/2021. Page 59, my lord.
Okay, let us have an idea. Facts. You are working as
I am working as a, my lord, ACF. Now,
now DCF.
DCF. So there's a criminal case pending, my lord, instituted against me. I was arrested, I was suspended.
Charge sheet filed?
No, not yet.
No charge sheet.
Not yet. So during that period, my lord, I was reinstated from the, because of this order of dishonorable purpose, I was reinstated. So FI was lodged on 29/10/2020. That page 56, my lord. Page 56, my lord. That is my FIR against me, my lord. I'll start.
When were you reinstated?
Reinstated, my
21.
lord.
22.
That is page 63, S 3/2/2022. 3/2/2022.
Chocos 2/3/22.
Yes. 2/3. 2/3/2022. Page 64, my lord.
And that was
DPC was held. 9% share
promoted.
promoted.
4/8/22.
Yes.
Now,
16 to 2020, my 16 to 2021, page 59, my lord, 9 persons who were junior than me were promoted.
promoted.
Enquiry report was submitted on, that is my lord, page 85 on 2010-2023. Enquiry report submitted. My lord. Page 85, my lord.
85 is the forwarding.
Forwarding, my lord, report was not given to me. That was, my lord, I'll come to that, my lord. Then, my lord, on 22 to 24, 26 other persons were promoted ACF to DCF. That is page 88, my lord.
Those persons who were promoted earlier, your juniors, now they are promoted as DCF
My lord.
to higher caste.
Higher post, my lord. So now, my lord, your lordship, kindly on 23 to 2024, page 90, de novo inquiry was initiated. So from that, my lord, I came to know that since, my lord, earlier inquiry was in my favor, that's why, my lord, de novo inquiry was constituted. Page 90, my lord. Page 90. That de novo inquiry is also in my favor, my lord. Page 94, my lord. Such the departmental proceeding could not be established from this end. So that was also.
No final order has been passed
My lord.
by the disciplinary authority.
No,
After this inquiry report, no final order has been passed, exonerating you.
my lord.
No order.
No.
And you retired on?
I'm retired on 31/12/24, my lord.
As ACF.
ACA. So, my lord, then, my lord, again, third DPC was there instituted, which I have challenged before this one state, my lord.
Arvat Asset. Or next to. That is, where is that Chocos? Do you know inquiry?
That is, my lord, your lordship will find. Page 73, my lord. Page 73 of the second petition, 6970. 73.
This is continuation of the earlier one.
My lord. So, my lord, one after another, my lord, this time he retired, and without giving any reason of disagreement, my lord, without hearing me, my lord. So that's why that is stayed by the reasonable court, my lord. By this time I am retired, my lord. Although I am retired, they have, my lord, because I am a very efficient officer, that's why, my lord, they engage me in some other post in the department.
We have received our pairwise reply, madam. Just one more opportunity, we would like to file it.
So why this repeated inquiry? Two inquiries you could not find against him anything. Now you have initiated a third inquiry.
Because
And in the meantime, he has retired. Now, because of this, keeping him under a cloud, he is not promoted.
my lord, enquiry remains the same. Only thing is the presenting officer. He the first
You concluded that inquiry, the earlier inquiry.
Yes.
Now, what was the need for not taking that inquiry further and holding a fresh inquiry? What is the reason?
because my lord,
That's the only thing we have to examine.
Yes.
A.R. Deb onwards, 1971 Supreme Court said that you cannot have a repeated inquiry till the report is to your liking. So there has to be something on record. What is that something? You have received your parawise.
Yes.
From that parawise, what is emanating?
My lord, the explanation given by the presenting officer in the first inquiry was that because criminal charges are pending, so we cannot proceed. That was his conclusion, my lord. So that was found unsatisfactory by the disciplinary authority, and they are under the impression that a departmental proceeding need not be dependent upon conclusions formed in the criminal proceeding, and that is
Where
why.
are the records where you have
No,
done?
that is first one. What is second one, my lord?
And this, we'll come to that. Where is that first inquiry? That is the opinion. You have done a second inquiry. Now, why was the second inquiry also not accepted and a third one was required?
Because my
Three inquiries now.
My lord.
Hmm,
That third one is stayed by this honorable.
I know. First one, I accept your plea that the presenting officer's view is apparently incorrect. There is no bar. But during the inquiry, he had projected before the inquiry officer, I have got no documents to establish the charge against the petitioner. So give me some time. So that went. You had a second one. Now, why was the second one not taken to its logical conclusion and the third one came in?
second one, my even before proceeding, the first presenting officer again was insisting on the same stand.
Where is your records to demonstrate?
I would like to, my lord, bring it on record. I have it with me, my lord. I just could not take the printout, but I.
Heard Mr. T.J. Monta, Learned Senior Counsel, assisted by Mr. P.P. Dr. Learned Counsel for the petitioner. Also heard Mr. I. Thakur, Learned Standing Counsel, Forest. Heard the Learned Counsel for the petitioner, Senior Counsel for the petitioner at some length. Also, Mr. I. Thakur, Learned Counsel for the respondent, submits that he would place the relevant records pertaining to the departmental inquiries, departmental proceedings instituted against the petitioner on the next date of listing. Registry to list this matter again on 5/2/2025.
My lord.
We don't want a affidavit, we want the records.
That is the only more.
Only.
Records.
And Mr. Monta,
My lord.
one factor you will have to address this.
My lord.
See, if I direct you to now be promoted, Amal Satpathy,
Yes.
if I direct you to be promoted now, I'm passing the order. Just presume that you are directed that you will be now promoted. But you cannot assume the charge of that.
But other benefit I'll get.
But no, if you can't assume, how can I give you that other benefit? That is what is,
Then, my lord, then your lordship kindly.
that is why Dr. Amal Satpathy's case you will have to
My lord.
distinguish.
Otherwise, my lord, this is one kind of, my lord, procedure, they will, my lord, defy my legitimate
I
claim.
know that, but the Supreme Court has laid down a law in that direction.
My lord.
That after retirement, you cannot. So here there is one way out because in the earlier proceeding, first case, there is a direction by this court that pendency is not a
Not a
bar.
bar to reconsider. That is.
So now you taking clue of that, you build up your,
My lord, I'm very grateful to your lordship and that, yes.
because otherwise that is a bar on me. Amal Satpathy is a bar on me.
Although I'm entitled, but I'll not get benefit.
That's what the Supreme
lord.
Court has said. Now, that case itself is very specific.
My lord.
There was a recommendation in favor of Dr. Amal Satpathy for promotion, but he retired. Recommendation was there. He retired. Supreme Court refused. So,
My lord.
Mr.
Definitely,
Doctor,
definitely, it's very good. My lord. it's
work
very nice.
out on that.
My lord.
But if I find, okay, I can't promote him, but considering the manner in which you have conducted the inquiry, I am within my powers to impose compensation. Keep in mind of that. Amal Satpathy, maybe I'll not be
My
able
lord,
to direct, but the manner in which you have conducted the proceedings, not very satisfactory. We can pass on this. I'll compensate him to the extent that he would have got in his promotional post. And the reason for that is the submission by Mr. Mohanta that even with this background, You have again retained him in service.
Yes, now still continuing, my lord. They want my service.
No, no, that is
Senior
disputed, my lords.
That
That
is
is
senior
disputed.
counsel.
He's not, no, my lord, he's not there. He's being engaged by some society, my lord, not in the government service.
Oh, in a society, your society.
No, no, my lords, no. Not our society. No, my lord.
Manas Tiger.
No, my
Yes.
lord, no, my lord. There's an NGO, my lord. That I'll clarify, my lord. That is disputed, my lords.
Very emphatic.
Yes, my lords.
Very emphatic.
They are very prompt, my lord. But your lordship kindly see
But they have not filed an affidavit.
till in anyone.
No, it has come, it has come, it has come.
The
We are
record
not
which was
concerned with the
put
affidavit.
today,
We are concerned with the records.
Record no hoy to.
But
Today
he
we have
says the
this
record.
my lord. Today it was not record. It was.
No, no, no.
caravan.
I have directed for production.
Yes, yes, I'll bring it. We'll bring it.
Okay.
Develop.
We'll see next day.
Lordship may take it up after some time. Miss Bora, she is on the way. She's downstairs.
After some time, Miss Bora is coming.
May I please, your lordship? Lordship has heard the matter to some extent, lordship. The 64, page 64 is the SOCOS notice. lord. This case, lordship, SOCOS was issued, lordship, without any article of charges, statement of allegations, and list of documents as witnesses, lordship.
Your case is that you were working,
Yes, lordship.
and for that you have given a certificate from Dispur
Yes, lordship.
circle.
Yes,
But where you are in Amingaon,
yes, lordship.
how can that be?
But lordship, the government has passed.
The area
Yes,
under the Dispur cannot extend till
but
Amingaon.
lordship, ultimately, government has passed this, sir. Government has clarified that by way of affidavit, lordship, that I am working, lordship.
Yes, madam.
Not working.
Yes, working.
No, no, lordship. On this specific date, he was found to be working, lordship. Our affidavit is very categorical, lordship.
To stand, lordship.
Okay. Mr. Kulta.
Yes.
I've forgotten the facts. You will have to get me back the facts.
Lordship, can it be taken
Mr.
on the second half, lordship?
Okay.
I
Yes.
can
Mr.
also,
Chaudhary.
because I also could not go through the files, lordship.
Mr.
Second
Chaudhary, you have some matter. Next. That regularization.
Yes, yes.
Where is Mr. Gogoi? Who is Mr. Gogoi? Mr. Gogoi, that matter which had gone up from the division bench to Supreme Court for Polytechnic and
It is pending, lordship.
no. There was a direction I have been informed by some other case that the Supreme Court had required the state to explore whether between those candidates a selection can be held and the appointment.
Because already we have filed affidavit, we cannot, lordship.
You
We have
have
already filed affidavit, lordship.
no
already-
outcome.
No outcome, no outcome. Interview process is already finished.
Because
We
this
will
is
apply.
also in the same,
No, not same line.
no. The division bench judgment. The
My
facts-
lord judgment is covered.
the covering.
My lord judgment. covered.
So why we should not wait for that?
Then lordship may wait.
Mr. Chaudhary, what had happened was there was a petition filed by Polytechnic employees, teachers, and engineering college teachers. Similarly, that they were appointed through a walk-in interview. They continued for a long time. Parallelly, there was selection processes, which they did not appear. Same like your thing. And the learned single judge on consideration dismissed the petition. Matter came up before the division bench. And Jaggo and all those decisions were placed.
Including the latest one being Dharam Singh.
Dharam Singh.
All are discussed.
Everything was placed
Yes.
and the matter was considered and the appeal was dismissed. Appeals were dismissed. Against that, the matter has gone up to the Supreme. Now, there is no stay, but I have been informed, I don't know exactly the facts.
Notice has been issued.
Notice issued. What the Supreme Court wanted the state was that they were working for like you only, they were working for a long
Very
period
long
of
time.
time. So a selection between them was proposed. Only between them and then to take the matter forward. Now, Mr. Gogoi says that the state has filed an affidavit wherein they have taken a plea that it's not possible. So, if
The Supreme Court has closed the matter.
no, that is what I'm saying. It's not closed. So shall we wait for that? Because that may have a bearing here.
Yes.
Because if the Supreme Court, otherwise, I am bound by my decision of the division bench.
My lord judgment fully covered by my lord.
I am bound by my decision because I have taken into consideration all these aspects, dismiss the matter. Matter is pending before the Supreme Court. So, Mr. Chaudhary, I can apply that decision and
Close it.
close it. But if tomorrow that comes in
Court
your
comes
favor,
with-
why trouble these people with further proceedings?
Our prayer was not regularization per se. In fact, when the matter was placed before the government, three options were kept open. There are some teachers of the education department who are being paid fixed pay of rupees 55,000. Then, my lord, there is a concept of near regularization. Then in Upendas's case, the state came up with the innovative idea that we'll pay them minimum of scale until the age of retirement. My lord, we are not sticking to regularization per se. In fact, if your lordship would kindly come to this document, my lord. এই যে হেৰিখন এইটো ক'ত গ'ল এই যে দিছিলে এই যে আমাৰ এই যে
The opinion of the advisor of the education.
Let's come to page 20, my lord. 20. After perusal of your letter with so-and-so, I have the view that there are either 2 or 3 options for the matter. Near regularization, fixed pay regularization. Near regularization and regularization would require fulfillment of UGC criteria like minimum, etc., etc. In addition, vacancy position of the colleges would come into picture. If they're advertised afresh, the said 73 number of candidates would not be able to compete with the fresh candidate. As your kind self is aware, recently Cabinet has granted monthly remuneration of 55,000 to assistant professor working for fixed pay in provincialized colleges. In my view, the same may perhaps be given to 73 number of candidates. Now we are boiled down to 33 million. But if we go by the latest decisions of the Supreme Court, where my lord, Supreme Court has taken a very compassionate view of the matter.
That's true.
And my lord has evolved a criteria to give succor to this kind of my lord teachers. It is only in that light, or we can wait, my lord.
I think, Mr. Chaudhary, better to wait because if that judgment is turned around, set aside, then everything will be there in your for regularization. Forget near regularization. It will be for regularization per se. If that decision Supreme Court works out a modality that there would be a selection between these people, because admittedly you don't have the qualifications requisite for appointment as a teacher. So to put you back.
But we are all PhD holders, my lord. All of us. Mostly, na?
Net will have to be. PhD is, I think, subsequent, not within the cutoff limit. Net and slate is required. In that case also, we faced with this problem.
That case also, my
In
lord.
fact, in this case, my lord, the process was
I think
carried on.
Dealt with that aspect also.
Lordship. That
It is only in the affidavit government has come up with this stand that their cases were considered. Now it cannot be, given a consideration.
Because there was a cabinet decision also. Matter was placed before the cabinet also.
Since some relief is to be given to this present set of petitioners, there has to be a decision by the cabinet.
How old are you all now? Are you within the age of
No,
recruitment?
We're all,
Even lordship, I
we had appointed
Mr.
between 10.
Gogoi,
lordship.
why this adhocism? Forget adhocism in other.
It is not advocacy, lordship.
No,
I
no.
just clarify, it is not advocacy, lordship. It is purely engaged by the college, lordship, after bar from the government itself, lordship. Repeatedly, we have the OM, lordship. I place it everything. Even I clarified one thing, lordship. After Dhorong Sim, one co-equal bench of the Honorable Supreme
That
Court
we
has,
have dealt with in the
Supreme
other.
Court has passed the order, negated the claim by relying the constitutional bench judgment.
Uma Devi was gone back to.
Lordship.
But that is in a minority. That
Lordship.
judgment,
That
unfortunately, is in
judgment,
a
lordship,
minority.
Honorable Supreme Court, but that
I
Dhorong
think
Singh,
I have referred to that judgment in my order
Lordship.
passed in the division bench.
Lordship, Dharam Singh, Joggo and Shivu.
And that
That
Tamil
particular
Nadu
judgment
case.
was passed by
Tamil Nadu,
one
Tamil-
Sripal.
Sripal.
That particular judgment was passed by the Honorable Division Bench of the Honorable Supreme Court, same strength, same judges. But after Dharam Singh, another Division Bench of the Honorable Supreme Court clarified Dharam Singh, Sripal and everything, passed the order and
I think we
negated
have
the claim.
considered
I
that
will place
also.
it, Lordship.
I think we have considered that
Lordship,
also.
Lordship had considered it. And after that also,
The
two
learned
judges,
counsel for the parties. So it is submitted at the bar that issues that a decision of the division bench of this court in writ appeal number,
Lordship, I'll provide you.
writ appeal number so and so and so and so, 49 and 50.
Lordship, 4950, Lordship.
An appeal was carried, was filed before the Honorable Supreme Court. So they said issue appeals are presently pending
Lordship.
consideration before the Supreme Court. Accordingly, registry is directed to list this matter after 4 weeks. So the parties are at liberty to make a mention of for listing of the present matter on disposal of the matter by the Supreme Court.
Lordship,
You
Lordship.
kindly give Mr.
Yes,
Das the numbers.
Lordship, I'll provide you. Oblige.
Because Mr. Chaudhary,
Anyway,
otherwise I am bound. I'll have to follow my order. Because I've considered all these things, right, wrong, different thing. But it's before the Supreme Court. Let's see what the Supreme Court says.
Even Supreme Court observation is there, Lordship, not for selection, Lordship, if you can, Lordship. If that judgment observation is that a government can accommodate them by a special, Lordship, recruitment
My order.
process. That was also already have filed affidavit, Lordship.
Okay.
That was.
But if the Supreme Court decides in that manner,
Ah.
which it may,
Otherwise,
considering the trend,
if we go.
then they'll also be getting the same benefit.
If we go by the latest judgment of the Honorable Supreme Court, that will against the petitioner, Lordship.
there's nothing like
Again-
latest
again-
judgment,
again-
this judgment.
against
the
the
end of the
petition.
day,
See,
it's
the
principle
question
of law
is-
which is
The
important.
question is, they are working under your nose.
Lordship.
Uh,
If you wanted them to be working,
Yes.
which shows that the students,
Lordship, we are already given.
then what steps have you taken against those people who have appointed?
Lordship, we have already given the various communication to them, Lordship, ousted to them, Lordship.
Yes.
Otherwise,
High
Lordship, we
time.
go by the rules, Lordship.
Mr. Gogoi,
Lordship.
it's high time that courts take a notice of this issue.
Lordship may take,
Because
one
these
hand
people,
not you will
Lord-
avail of
Lordship,
his advocate.
the problem is,
Lordship may take judicial notice against those person, even the hearing officials, but we
no,
cannot.
why should
violate
the court take a notice? Why are you not taking that?
We are,
That
Lordship,
will embolden us to further take the matter forward.
Lordship, after when we have issued a letter to the authority to Lordship remove them, they have approached this court, Lordship. In every cases, Lordship. That is the reason, Lordship.
And see,
That is
if
the
the
reason.
college is
So,
requirement
that's
of
why
10
blame
teachers,
judiciary
That is
also.
the
no,
reason.
no, if the college is requirement.
I am not
No,
blaming the judiciary.
No, no,
I am
very
not
si-
blaming the
Very
judiciary. I am
Mr.
saying the
Mr.
conduct of the
Mr.
petitioner,
Mr.
Lordship.
Mr.
I'm
Gogoi,
saying the
Mr.
petitioner.
Gogoi, Mr. Gogoi.
Well, my learned friend
No, no, no,
is
it's
in the
okay,
habit
it's okay,
of.
Mr. Chaudhary.
No, the-
It's not that,
he is
it's
the
not that,
only
it's
person
not.
left in
Mr.
this
Mr.
country
Gogoi,
Lordship,
Mr.
he-
Chaudhary,
defend the
please,
state of Assam.
No, Lordship,
please,
no, Lordship.
please,
This is
please.
his view, Lordship.
Please.
This is his personal view, Lordship.
Hear the court.
Lordship,
See, if in a college, this
Lordship,
is a
Lordship.
perennial problem.
Lordship,
If in a college, as per the UGC guidelines
Lordship.
or all the,
Lordship.
you require 10 teachers for a particular
Lordship,
subject.
Lordship,
You appoint 5.
Lordship.
You don't appoint another
Lordship,
5.
Lordship,
Huh? The
Lordship,
college is forced to bring in another 5 because it's a question of their affiliation.
Lordship.
Now, in this circumstances, either the government steps in, creates further 5 posts, hold a regular selection, appoint it. Why this non-sanctioned,
This-
contractual?
Lo-
Because see, these are also human beings.
I am not.
They are
saying
also
Lordship.
human beings.
I am
Once-
not saying, Lordship.
See, once a man gets a job, he goes to a college. People don't know whether he is on contractual or he is a ad hoc
Lost.
or he is a regular.
Lordship,
He is a teacher of a college or master.
Lordship.
Precisely.
That status he gets. And then that's human tendency, he starts adjusting in his life in that. One fine morning, he's not there. Think about that apprehension. Think about the legitimate expectation he had.
That's why, my Lord, Justice Bikram Nath has said,
That is
you
there.
cannot use Uma Devi to exploit these people. Basically, this is exploitation.
It's
And
further.
these people have any
Mr. I am
I am
bargaining
saying
power?
that, Lordship, it is not exploitation, Lordship. We are as per the requirement, Lordship. As per the UGC's requirement, all posts are there. Beyond that, they have engaged it,
You've
Lordship.
got to work out something
Yes.
that, okay, from today onwards, we are not like in the foreign countries.
Lordship.
We don't want any regular people. We get, Mr. Chaudhary is the best, we'll bring him. Then you get some other best. Mr. Chaudhary, thank you, go other best.
That
ones.
part cannot, that part cannot,
That
that
is
part
what is
cannot.
happening.
We go by the law, Lordship, as per the requirement, that post is there, Lordship. It is their own fault,
Mr.
Lordship.
Das,
It is
take a
not
tab
our
on that Supreme Court matter. Moment it
Yes,
is
sir.
there, make a mention.
If we get to know, we'll mention. them.
Mention them. We'll see. Yes, Mr. Gogoi.
Oblige, Lordship.
Hey, to my doctor.
Eleven.
11.
Five, 10.
We'll finish up with Mr.
But the petitioner was working as a branch manager.
Where is Mr. Sharma? Get hold of Mr. Sharma.
He was working as a branch manager
Hmm.
at the relevant point of time
Hmm.
in the bank.
Hmm.
Then during his incumbency, there comes some directives for development of business.
Branch manager of?
Latakandi branch.
Hmm.
The period was from 15th of October 2012 to 21st of August 2013.
Hmm.
In the month of March 2013,
Hmm.
an order was issued suspending the delegation of powers of the petitioner. As a branch manager, he had powers to sanction loans, disburse loans, procure business. But for some reason, on 7th of March, Miller, this power was suspended.
Hmm. Hmm.
That was in March.
Hmm.
Now, in the month of May thereafter, there was a meeting amongst the senior managers of the bank, and the decision was taken that he should go forward for securing better business of the bank.
Hmm.
That order, your lordship will, the resolution your lordship will find at page 25.
Hmm.
Annexure
6/5/2013.
P2, yes. 6th of May 2013. In pursuance thereof, it was his understanding that perhaps the first order, that was 7th March 2013, that was given a backseat, and therefore he went ahead with the task of sanctioning loans and disbursing loans under various schemes. Right.
Now, Mr. Doctor, once the delegated powers that was given to you for carrying out various activities of the branch manager
Yes.
came to be suspended. Now, was anybody else in the branch empowered in this connection?
No, no.
So,
And therefore,
between 7/3/23 and 6/5/23, in the branch, if some such issues came up, how was it being dealt?
that aspect is not very clear. But what the instructions were that this suspension was leading to the powers of sanctioning loans to the third parties.
Okay, then
Because the branch in a rural area, branch sanctions various loans, Kishan credit loans and other loans, all sponsored by the government. These loans are sanctioned through the branch manager. Now those powers were suspended. But thereafter, this P2, Annexure P2, page 25, Memorandum of Understanding comes.
And that is also addressed to you only.
That is also addressed to me and requiring me to give, and a target was given that I was to fulfill that target. And it was the target for the financial year 2013-14.
Hmm.
Now, in pursuance of this, Miller, then I go on sanctioning loans. Whenever there was a sponsoring agency or it came through the sponsoring agencies, Miller, the loans were sanctioned.
Hmm.
Now, the charge sheet finds fault with me on broadly 2 counts. First of all, in view of this suspension of power, you could not have acted in defiance thereof to sanction loans. This is one angle of the misconduct alleged. And the second angle is pertaining to my activities, which are rather clerical in nature. so to say, that after sanction of the loans, I was required to send the proposals and the details of the creditors to my higher offices. Those were not done in time. There were certain audit conducted, and in the audit it was found everything had happened prior to initiation of the DP. There was an audit conducted in the branch, and in the audit, my lord, it was detected that I had not put forth the loan portfolio in the proper perspective.
Now, what is 13.7 and 9.9?
13.7 is, my lord, page 26. 13.7 was a letter given to me.
Why this explanation?
Yes, why DP should not be initiated. These are seeking for my explanation.
Two
Now-
loans.
Two loans. Now, before that, my lord, there was a special audit in the branch. That was based on which, my lord, an audit report was created. That was 17th of August 2013.
Audit report.
Yes, and based on that audit report, my lord,
Audit report is dated 17 now.
17th August 2013, and based on this audit report, my lord, the irregularities were identified. Irregularities, so to say, in not putting forth the loan portfolio to the higher offices and seeking their
Let us see page 27.
page 27. It is dated 9th of September 2013. Sri so-and-so is informed that the following acts of omissions and commissions are reported in audit report, date of that is 17/8/2013 against him, which he was while he was working as branch manager so-and-so. After the last audit, branch has sanctioned and disbursed 479 loans, excluding secured loans, amounting to 2.7 crores. 390 accounts amounting to 2.17 crores are sanctioned and disbursed during the period of Sri so-and-so, for which not even a single account has been reported in the delegated authority statement. Now, the requirement was that the moment some loan accounts are opened and the loans are sanctioned, then this in the form of a statement, it has to be uploaded to the higher authorities. No M227 has been submitted by the branch to the regional office Guwahati after August 2012, despite of sanctioning huge amount of loan. Notwithstanding suspension of delegation of power by the RO Guwahati.
So this is the next one. Second
Yes.
paragraph is one charge,
Yes.
one allegations.
Yes.
Second is the next one.
The second is next ones. And further instruction of regional head has observed from branch visit report dated so-and-so not to disburse any further loan. Sri Chakraborty sanctioned and disbursed 61 loans as mentioned below after suspension of delegation of power with limits of 69.53 lakhs, which is a clear deliberate violation of the instruction of the higher authorities. Now, this is the details, and in the last column, your lordship, last two columns.
What
your
is
lordship,
UGC account?
UGC account, my lord, that I am not very clear.
Okay, continue with 28.
A scale of finance is not adhered to in any UGC account, and sanctioning of loan under government sponsored schemes. Many of the UGC and government sponsored accounts were sanctioned beyond the service area of the branch without obtaining no dues certificate from the nearby banks, namely so-and-so, so-and-so. Assessment of term loan is not done in any account. There are gross violation of set norms of the bank for finance, that namely pre-sanctioned formalities are totally ignored. Loan has been disbursed in respect of account number so-and-so, so-and-so, own staff so-and-so without obtaining any security documents. Not a single document obtained in support of advance granted since October 2012 is complete in all respect. Entire set of document kept blank in respect of 262 accounts. Wherever security document obtained, executed very casually, that is kept mostly incomplete. Amount is not written in words. Borrower has not signed on all pages. BPN obtained in BPLR format. Security documents are understamped in all cases. There is diversion of funds due to the non-creation of unit as per scheme. In few cases, Sri Chakraborty disbursed loan amount in NPA borrower account. Many of the newly sanctioned accounts are under stress category reported in EAS SMA list. Though RDO has been posted in the branch, he has not participated. His services were not utilized in loan processing, barring 2 or 3 cases. Now, thereafter, there are irregularities noticed.
Then you submit a reply to that.
Then I submit a reply. My reply, your lordship will find at page 34. Particularly, your lordship may notice paragraph
So
3.
basically, you have admitted to the fact with an explanation that yes, the documents which are required to be processed, you had not processed. An explanation is there.
Yes.
Then why? Because time constraint was there.
And it was all on my position, but it was not, I mean, the filing was not properly done.
Then that was not found to be satisfactory.
So here, there is one incident occurring in between. After this audit report came and the irregularity, because irregularities your lordships have seen, these are mostly in nature of paperworks. Like I did not get the signature on.
We'll go to it.
Yes.
Now,
After the audit report came and the irregularities were notified, all these irregularities were set right.
Okay.
All of these were set right. Now, even after that, my lord, therefore, my lord, I said that the main plank of the attack under the charge remains on the first count, that since there was suspension of your delegated power.
We'll go to it.
Yes. So all these irregularities were rectified. That was prior to initiation of DP. Now, therefore, the authorities therefore say that since there was delegation of power, you could not have go ahead with the sanction of loans. This is one aspect of the matter.
When were you transferred out of this Latakanti branch?
That I'm just
Okay, fine. We just give me that date.
giving the date.
Now comes the article of charge.
Now comes the article of charge. That your lordship will find at page 36.
Yes.
Now there are basically charge on 4 counts. The first was, it's a 2-page charge sheet, my lord. Rather 1.5 page.
Small one, we'll
Small.
just go through it. Read it.
Yes.
Second paragraph. On that.
It is evident that Sri Chakraborty committed various irregularities while sanction and disbursement of loans in 390 accounts, aggregating to rupees 2.17.
That is the first one in the earlier.
Yes.
9/9/2013. This is the first one.
Yes.
Hmm.
During his tenure as branch manager of Latakandi branch, for which not even a single account has been reported in the delegated authority statement. No M27 statement has been submitted by the branch to the regional office after August 2012. Now, his period was from October 2012 to 21st August 2013. Your lordship was asking me
After that, 22nd onwards, he is not there.
Yes. His delegation of powers have been suspended by RO letter number so-and-so dated 13th March. Despite of that.
So the first part of this paragraph,
yes,
the offense alleged is, the allegations is prior to 13/3/2013.
Yes. Prior to 13/3/23. Despite of that, he had sanctioned further 61 loans aggregating 69.153 lakhs, which is in gross violation of instructions of the higher authorities. He had also failed to adhere to the various guidelines procedures while sanctioning loans such as scale of finance, loan under UGC and government sponsored schemes. Where
So,
sanctioned.
Mr. Doctor, from this we can get 2 sets of allegations. One,
Yes.
prior to 13/3/2013, that is 390 loan accounts were created. 2.17 crores was dispersed, but this was not reported to the higher authority.
Higher authority.
So that is gone. After its suspension of your delegated powers
Yes,
on 13, with effect from 13th, after 13/3/2013,
13.
you further sanctioned 61 loans,
Aggregating 69.53
lakhs. While that period was
Under,
that- under suspension.
yes,
For that, your plea is that the memorandum dated 6/5/2013 had required you to do so.
yes.
That's a different
And even set me a target.
target, 700 crores or something, a target was set. So these are basically the two allegations against you.
Yes,
Now, the third one we will find in the third paragraph.
yes. It is also held on record that to deposit of total 10,17,671 is credited to his OD, SB and loan accounts maintained at Karimganj, Latakandi, Dharmanagar and Katlichara branches respectively by Sri Chakraborty from 15/11/2012 to 3/7/2013 on different various dates during his tenure as branch manager, Latakandi branch. Now, this speaks about deposits being made to my OD and SB accounts.
You say that you brought a flat, but around
Yes.
24 lakhs,
Yes.
but that was through the financial support given to you by your father-in-law.
Yes, by my father. And
Father or father-in-law?
father.
Father.
And otherwise also, there is no allegation in the charge sheet, although it mentions about there being a credit in my account. There is no allegation in the charge sheet that it was a quid pro quo for sanctioning of the loans. That is not even an iota of allegation of this kind. The aforesaid acts of omission and commission on the part of Sri Chakraborty constitute the following misconducts, and he is hereby charged of the same. Now, 4 acts are viewed as misconduct. Sri Chakraborty is informed that a detailed statement of allegations on which the aforesaid charges are based and the list of documents through which and the list of witnesses through whom the above allegations are proposed to be sustained is enclosed. Sri Chakraborty is hereby called upon to submit his written statement of defense within 7 days of receipt thereof by him as to why further disciplinary action should not be taken against him for above lapses on his part. Sri Chakraborty has the permission of the undersigned to visit Latakandi branch for 2 days to inspect the relevant records for submitting his written.
Okay, what is the finding of the inquiry officer?
Now, inquiry officer has expanded these 4 charges into 9. Inquiry officer's report, your
9 would be,
that your lordship will find at page 46.
if you can come to page 39. Please, 8 I can find out.
Yes.
39, these are the broad areas wherein various schemes under which you sanction those loans.
Yes.
That is 1, 2, 3, 4, 5, 6, 7. 7.
Yes.
And 1 is your account.
Yes.
Yes. Now,
And
what does the inquiry officer say?
Your lordship will kindly come to page 46. That is the inquiry.
Inquiry report.
That is the inquiry report. Now, in the inquiry report, my lord, your lordship will kindly see the it starts from, the charge-wise, he has dealt it on the basis of the charges. It starts from page 52. Sorry,
50.
50. Now, analysis of evidence and findings. Analysis of evidence and findings. Now, here I refer to material exhibit number 1 and deposition of MW1, wherein it is confirmed that the delegated authority of Chakraborty was suspended by NRO with immediate effect by memorandum number so and so. I again refer to material exhibit 2 and deposition of so and so, from where it is confirmed that the loan documents are partly filled in or blank, undated, unstamped, without signature of borrower and also without signature of sanctioning recommending authority. All the KCC loan document, KCC is Kishan Credit Scheme, my lord. Loan documents starting from account number so and so onwards were found blank and signed by the borrower. TSO also financed some of the loan accounts out of the service area of the branch. It is confirmed that from MEX2 that loan disbursed rupees 4 lakhs, 3 lakhs and 1 lakhs in account of so and so were credited in SB account of the borrowers. Similarly, loan amount disbursed in phases in loan account number so and so were also credited in their SB accounts. In loan account, a so and so amount loan disbursed in phases were also credited in the CD account of the supplier who is a NPA borrower. Similarly, in loan account numbers on number, these are basically the details of the loan accounts through which Millard.
So, Mr. Dotto, the purport of the charges we'll consider. These conclusions that have been reached is based on the materials that are there in the inquiry, right? There is no dispute on that. Whether that constitutes a misconduct or not, that is something we will argue. You argue, we'll consider. But the submission that the conclusions that are recorded are based on the materials available in the inquiry, statements of the various MW1s who had appeared, right? Now, finally, the charges have been held to be proved against you in all counts, right? And the charges also include allegations against you that you had sanctioned loans to persons whose accounts were already held to be non-performing assets.
That is also not correct.
How have you dealt with that?
Well, I filed a review. Well, after the
Now, against this finding of the inquiry officer,
I filed an appeal that was dismissed.
no. You might have filed a representation.
Yes, I filed an appeal. The appeal was dismissed, and there is a provision in the banking
No,
regulation.
that is after the disciplinary authority's order.
Yes, yes.
Now, once this inquiry report is given, was a copy not furnished to you?
Yes, that was given.
Then what is your response to that?
Now, I preferred an appeal.
No, no, no.
Oh, your lordship is asking that reply to the inquiry.
Representation against the inquiry.
Well, that was not done, perhaps.
Then see that would now put you again a step back because you have not disputed the findings of the inquiry officer.
No, that was challenged in the appeal because the banking, I mean, the regulation of the bank provides for filing of an appeal.
After the disciplinary authority.
Yes.
So disciplinary authority accepted and dismissal of service was given to you.
Yes.
68-16.
Yes.
Now, where is the appeal?
Thereafter, there is a provision for filing a further review, which was also availed of by me.
That also dismissed.
That also dismissed.
Then appeal.
And yes, then this writ petition.
Where is your appeal? Where is your appeal memo?
My lord, that will, your lordship will find at page 72.
72 is the appeal.
Sorry, 72 is to the reviewing authority. The appellate order is at page 70. My lord, I'm just making a submission in between, my lord. In this review also, I highlighted that all the loan accounts which have been reported and which have formed the subject matter of scrutiny, my lord, all these loan accounts were regularized. I mean, the bank got back the money against the loan sanction. At least till the date, your lordship will kindly see this. I have also referred to a particular document in the rejoinder. I have filed it, although they disputed it, my lord, in the written statement. In the rejoinder, your lordship will find. I have given a list of the account-wise status report. Your lordship will kindly see from page 260. The account-wise status report was given by me, showing that all the loan account, those that were sanctioned by me, were regularized by the borrowers.
Page
260. To 58 is my appeal, my lord, before the appellate authority. I indicated before them that all the accounts were closed and it was all accounts were rated as A1. A1 means, my lord, the money has come back. So it is not even a case that because of the sanctioning of the loans, the bank had suffered some loss. Although, my lord, the inquiry officer has returned a finding that financial loss has been caused to the bank. But this was highlighted by me in the appeal. They have gone on a very...
No, I just want to know from either from the appeal or from the review. Appeal is, I think, page 233, 150.
Appeal is 258. In the rejoinder, your lordship will find that.
Okay, let us go through that second paragraph.
I do admit that I have committed some lapses during the tenure of my branch managership at Ratagandhi branch. Ratagandhi was my first posting as branch manager. As a branch manager, I was lacking in knowledge and inexperienced. Due to pressure from the district administration regarding sanction and disbursal of KCC loans to the farmers, I had to follow the practice of the branch, which was followed by the previous branch managers, and I had to sanction large number of KCC loans, which was within the ambit of the target fixed by the RO Guwahati for the branch. It is unfortunate on my part that my explanations to the disciplinary authority and also to the inquiry authority were found to be not convincing, satisfactory, and was brushed aside. I would like to take a few of your valuable time to go through the status report of the loan accounts sanctioned by me, for which the departmental inquiry was conducted against me. The status report is enclosed herewith. You will be glad to find that many of the loan accounts are already been closed by
Full repayment.
full repayment, and out of 390 loan accounts, only 13 loan accounts are in NPA category A2, A3, for which also chances of recovery are there by adjusting the liquid security, disposing of the primary security and collateral securities. All other existing accounts are in standard category. It is worth mentioning that all the farmers are recycling their loan accounts for fresh cultivation. I take this opportunity to apprise you that during my 10 months period as branch manager at so-and-so, I had increased the deposit of the branch by 1.12 crores. The profit earned by the branch in March 2013 was 26.33 lakhs, which was much higher proportionate to March 2011 and March 2013. The operating profit up to September 2013 was rupees 12 lakhs. NP of the branch was well under control with negligible slippage during my period. I can jolly well claim that I had been allowed to monitor the loan accounts after disbursements without having removed me from Latagandhi branch. None of the loan accounts disbursed by me would have slipped in the NPA category. I have joined Union Bank of India on 96, and having my old parents with 86 years of age and two so-and-so children, my family presently, I was the only earning member, and without my income, my family will be marooned and will have no other alternative but to go for starvation and misery. Except this Latagandhi branch episode, my entire service record is unblemished. With the above submission, I request your good self to set aside the punishment imposed on me by the disciplinary authority and give me an opportunity to serve the esteemed institution for which.
Okay, now, Mr. Doctor.
Now, this is the status report.
Mr. Doctor,
Okay.
your projection before the appellate authority is you have not denied what the inquiry officer's findings are. You have not disputed that. What you have said is that, see, maximum of the accounts are in the standard procedure because payments are coming in. Few accounts have been closed. 13 accounts have only been recovered. Few.
13 out of 390
90 have become NPA.
But there are chances of recovery because of the liquid assets.
But Mr. Doctor, the allegation against you is not the non-receipt of money or the loss occasioning to the bank. The allegation against you is that you have not followed the procedure.
Exactly.
For sanction of loans.
Yes. The allegation is that I
because see, luckily these accounts, maybe there is a recurrent nature of need of money because of the Kisan loans and all. The people have repaid. But what about the misconduct committed by you in sanctioning loans without following the procedure? Because that is where you are required to act in a manner more than required of a normal employee, bank employee. What do you say on that?
Now, my submissions will be twofold. First of all, whatever acts have been complained of against me, these are in respect of following in respect of not following certain set guidelines. These parts.
And you admit to that?
Yes. And I admit to that because these are all on paper. Only thing, for the sake of making a ground, it has been said that the documents have not been proved in the way it ought to have been proved in the inquiry and all. These are there. But if you Lordship will give a summary look of the matter. Because my endeavor will be only to find out an element of perversity in the finding. Or, and this is on the first count, and if this fails,
Proportionality.
then on the count of proportionality. That will be the only two things.
So
So having said that, my lord, except for the fact that the documents, because I have also taken grounds that listed documents were listed, witnesses were not examined,
because we find that the documents were exhibited through witnesses.
witnesses.
So Rup Singh Negi to that extent is satisfied.
My lord, I would say Rup Singh Negi will require some more compliance, but your lordship can also take a view
Because,
that
because you have not taken a plea to that effect specifically.
not
So
not
procedurally, we don't find anything.
My lord, in the writ petition I have taken, but in the appeal and review, my lord,
No, you
those,
have not taken because writ petition is your, not about the thing taken by the prejudice
But-
that was caused to him.
but
He has not, the prejudice cannot be something
but your
which will
lordship
be
can,
projected by the advocate in the writ petition, but not contemplated of by the petition
my lord
in
may,
the inquiry.
my lord may also see the review, my lord.
Hmm.
My lord may also see the review.
Page-
That will be at page 72. Because the appellate authority's order is again 1.5 page. The review will be at page 72.
This second paragraph, first line, is it not enough?
No, well, that's why I said, my lord, although for the purpose of taking some grounds in the petition, my lord, something has been taken, but your lordship will have a cumulative view of the matter. Now, question is whether these will per se become misconduct or not. The deviations in sanctioning the loans, and because this has to be viewed in my respectful submission.
That when the misconduct is viewed, it's not viewed from hindsight. It's viewed from a forward-looking at that point of time.
No, my lord,
At that point of time, because of these inconsistencies, the bank could have been exposed to, I'm just trying to elicit from you.
yes. Now here
Tomorrow, the loans have been met, repaid, there is no problem, everything was done properly. You could not make the papers in time because of the work pressure, 9 hours you're working, you could not have. That would be something in the realm of well-conceived proportionality.
But my submission is here, my lord. I'll try to substantiate my submission with some authorities. Misconduct will have to be viewed from the consequences that is following from my act. If my acts are so innocent, does not lead to any negative consequence on my employer, it cannot be per se viewed as a misconduct.
Sorry, I'm interrupting you again. That is something which the employer must, every employer then must have to wait for a considerable period of time to look into the consequences that would follow.
Therefore, my
But
lord,
there is another thing. Once you have done this, you have to take signatures, you have to draw up securities, you have to bring on record many things so that the file portfolio is proper. And then it is kept because tomorrow if the man defaults, the bank is not left high and dry to get it back. That's the intention.
yes, absolutely.
So when the matter came up before the knowledge to the authorities that you have been doing these acts, maybe to augment the income of the bank, that's a different thing altogether. But the moment you see it on that day, find that, Arey, this can now create problem for us.
No, here,
What has he done?
that's why, my lord, I said, the moment it was identified, these problems were identified in the audit report, those were rectified well in time, much before the initiation of the disciplinary proceeding against me. On the day of initiation, therefore, my lord, I have taken a ground.
You have taken a ground that it is not there.
Yes, because on the day of initiation of the proceeding, my lord, the disciplinary authority has to satisfy itself. There is a truth or otherwise of this substance in the substance of allegation.
Okay, in the inquiry per se, have you taken this plea that everything was in your brief or be that as it may anyway, or in your statement, that see I'll not call it an irregularity, the deficiencies
Yes.
in the documentation process was rectified.
Yes, that was done.
Have you taken that please somewhere?
Well, I'll just try to locate it in the written statement file.
Not, okay, written statement.
In the written statement file. That will be at page 44. Second paragraph. May I read it out to your lordship? Second paragraph. The statement of allegation states that not even a single loan account has been reported in the M27 statement and submitted by the branch to NRO Guwahati. In this regard, I would like to apprise you that no irregularities are now lying and all the M27 statements duly signed have been sent to the NRO Guwahati.
That is one aspect of the matter. That these are the accounts created and by me.
The deficiencies which were
No,
noticed.
the deficiency in each of the loan accounts. Where is that?
Well, that is M27 state because whenever
M27 is a statement.
where it is, my learned friend will be in a better position to explain it being a person from the representing the bank. As I understood it from the instructions, my lord, whenever a loan account is created, then this M27 statement is also a follow-up action. This M27 statement includes the details of the loans created, the collaterals drawn, or the liquid securities obtained. The details are enclosed in the M27 statement.
M27 was brought on record as exhibit.
Yes.
Uh,
And for all the 390 accounts, because the deficiencies were identified in the audit report, my lord, all these M27 statements were thereafter rectified. That was much before the disciplinary proceeding could start against me. And third paragraph, if your lordship allows me. What they have in the disciplinary proceeding, my lord, what they have gone is with the M20 lack of M27 at a stage prior to the audit report. Had they taken into account the M27 statements prepared after the audit report, my lord?
but the finding, if you can come down to page 50.
Yes.
Last, towards
Audit
the bottom,
report.
from the
Exhibit.
exhibit.
Audit report MEX 9 and deposition of into confirms on the irregularities of matter of 61 loan accounts which were sanctioned and disbursed by so and so, so and so. Sanctioned loan are not reported in M27. M27 was not submitted after August 2012. Now, kindly see my reply in 2014. Because whatever I am saying, my lord, they have taken the taken the M27 statements on the basis as it was featuring from the audit report, not what it was
So,
given.
where is the depositions, Mr. Sharma?
Yes.
Depositions? Record, inquiry record.
Yes, your lord.
So, when this was projected in the inquiry by the management witness, did you cross him on this point?
That is
Not there.
Inquiry, we can't go beyond.
that is not. I'm not sure, my lord. That is not on record.
Because it boils down to these three facts, whether the documentation was proper, M27 was duly made, subsequent consequences that will be in proportionality of the penalty. But for the charge to be established or not, this court cannot go beyond that. If these aspects have been established in the inquiry,
No,
that's the end
my
of
lord,
the matter.
my lord, perhaps your lordship can still go ahead with the aspect of inquiry as to whether these deviations. I admit, my lord, there were deviations
No,
on my
whether it is a misconduct or not, that is, we will not appreciate that. We will see whether how the employer has understood it. If that is not perverse,
No, here-
maybe we will not come in.
My lord, here, my lord, taking a cue from one judgment of the Honorable Supreme Court, in establishments of this kind, banking establishment or where they run on the statutory standing orders, industrial standing orders, Honorable Supreme Court has said that in these contexts, the misconduct has to be a defined connotation. It cannot be left to the understanding of the employer. Because unless and until it is a written or codified act forbidden for an employee to do, it cannot be left to the wisdom and understanding of the employers. Because in that case, my lord, it will not be possible of generating any definitive term. Because misconduct per se will have to be a very exhaustive term. Because it is impossible to my lord, sum up everything within the words. But therefore, the test is, my lord, whether the alleged acts have contributed to some negative consequences. There may be a perception, because therefore there comes the area.
There is another aspect in your charges that you had, every branch has a service area,
No, that I have clarified, my lord.
that you gave it beyond the,
My lord, because after the CIS system, CBS system, core banking system has come, my lord, the concept of service area has become diluted. Today, I am residing at Guwahati. I can secure a loan from Calcutta. That is possible. Even my lord, it's a day-to-day experience. And I have in my rejoinder also I have highlighted there are circulars from the bank itself. That because this service area concept has gone has become diluted after introduction of this core banking system. Your lordship will kindly see this in the rejoinder I have given. Oh, for a moment, my lord, may I just pass on the regulations to your lordship? Well, I am alleging in my petition, I am alleging some violations of it also.
your another aspect is that the inquiry officer only limited his consideration to the audit reports,
Yes.
not the DW witnesses that had come in.
Yes. Because that's why I said they considered the thing from the perspective of the audit report.
Yes, Mr. Sir.
Audit report will naturally
In
show
the
it.
inquiry, there was a defense witness produced by the petitioner.
Yes.
And the defense witness said his statement, that's why I want the records, that all the deficiencies pointed out were rectified. But I don't find the same being factored in by the inquiry officer in his report.
Yes, your lordship.
Preponderance would be after taking into account all the evidences.
Evidences, yes.
Okay. Not by ignoring something.
Yes, your lordship.
I don't find page 53.
.53 of the writ petition.
Writ petition.
Okay.
Charge number 1.
Is further deposed by the DW1 in question number 71 and 72.
No, just first line in examination.
In
chief-
examination in chief of defense witness, it is confirmed from DEX 5 and 13 that irregularities as pointed out in the special report is rectified. And it is further deposed by the DW1 in questions that 71 and this RDO of the branch is in habit of not attending offices and remaining absent of the.
Where are the statements of the witnesses, Mr.
And one thing, my lord, just before he submits it, the relaxation in core area, the branch area, my lord, that your lordship can also see from their own circular, page 250. As I said, core banking system, after introduction of core banking system, this has
What is the date of the circular?
7th December, 24th December 2004.
So it's much prior.
Much prior to that. Because after core banking system has come in, my lord, these concepts are practically of no consequence.
A loan can be taken, but your lordship,
Mr. Dr. With regard to your accounts, money being deposited in your accounts in on various dates, was considered as a charge in the inquiry.
That is my grievance, my lord, because it was not framed as a charge in the charge sheet.
Okay, fine. But there was evidence because this is materials on the your passbook.
And
your
it's
account.
my passbook, and I said that this is the money I had taken as a loan in purchase of the flat.
Have you adduced any evidence from the persons who had given you the money? Maybe your father.
No,
Maybe.
my father could not come in all probability. He was
Because
at that
the-
time also only he
The
was.
amounts, it seems, to have been deposited by various other people. Different individuals have deposited money in your account. So being a banker, and that too in a power to disburse loans, and it's just a preponderance of probability. The manner in which these accounts were, the amounts were deposited and the time of those deposits, which corresponds to the sanction of the loans by you. A presumption was drawn. Maybe this is
Quid pro quo.
quid pro quo.
Now that for that matter, my lord, my submission will be, for that matter, a charge was required to be spelled out in the
Let
charge
us
sheet.
go back to the charge sheet.
Your lordship will kindly see the charge sheet at page 44.
Not 44, 36.
Sorry, 36.
So here there is a charge.
No, here's a failure to take possible steps to ensure and protect interest of the bank.
No. The third paragraph.
Yes, but ultimately he summarizes the charge. The
No, no.
aforesaid acts of omission and commission on the part of Chakraborty constitute the following misconducts, and he is hereby charged of the same. Now, what are the misconducts viewed? He summarizes it in 4 charges, 4 distinct heads.
Oh, these are just, but the allegation, it is there.
No, he says, but he doesn't say, and in the inquiry, then if it is to be viewed as a charge, my lord, in that event also there has to be some link established in the inquiry that yes, although I have stated that I took the loan from my Keith and Keen, but the money has been deposited by so and so, and therefore it cannot be disbelieved that this was the quid pro quo. There is nothing of this sort in the inquiry report or in the inquiry at all.
Now, the statement of allegations also contains a scrutiny of accounts. Okay.
Page 41. It is on record that there has been deposit of huge amount.
Now
of
there
cash.
is a, see, it cannot be. You come to page 43. The cash vouchers pertaining to the deposits
Yes.
were made a list, part of list of documents.
Yes. But that's why I said, my lord, it has to be linked in the inquiry, my lord, that these are the cash vouchers.
That conclusion is there.
So that conclusion is in a very summary nature. That
No,
conclusion
that is what I wanted you to know. That when these documents were being exhibited, MW1 was depositing. What were your questions in that connection to?
My lord, the records are with him, my lord.
lordship, it is not.
You go through it. Huh?
It is not here, your lordship.
Why?
I mean,
That was the main
That's
thing
a-
you should bring it on record.
Yes, your lordship. Other file is being,
You give access to
yes.
Mr. Chaudhary or Mr. Doctor or his junior, whoever it is there.
Yes, sir.
Today itself. We'll forget we have Mr. Doctor has
Yes, he is made in advance. Yeah.
He will require a bottle of water now. This court may require more. We'll have it on Thursday. Mr. Doctor, so we have broadened out the areas.
Yes.
But I think, again, subject to what you finally say, case of proportionality. Whether,
Case of proportionality will be a better,
I think so,
better point.
better point for you. But there are decisions rendered by me, not one, maybe two, three. Bank employees, Dr. Saab was there, the bank, wherein I have said that following Supreme Court decisions that in case of a bank employee, one is, I think, Nilakanta Soikia. But
The basic thing is loss of trust.
loss of not trust, confidence.
Loss of confidence.
Basic thing is loss of confidence.
And I went into the Supreme Court judgments. Even the recent judgments have said when it's a bank employee, other things are not very important. If a loss of confidence can be presumed or worked out or culled out from that, that's enough.
But that loss of
That is why I was trying to
that
interact with you in that manner so that I can get something out.
no, loss of confidence has to have some anchor in the
Proof.
facts.
Naturally, it cannot be in the air. So
Because
MW1,
well, I'll find it out from there.
MW1, your cross, because he is the one who has brought on record all these things
Yes.
pertaining to 3 charges. So, and also the deposits, vouchers are there. Just see whether the deposits were made by you or by your father or by some outsiders. Because deposit by outsiders, again, you will have to have an explanation.
And naturally, my lord, that explanation has to be on the date of the inquiry, not today's
No, it
explanation.
cannot be. And if you are smart enough that it was by your father or by you yourself, it would be a different connotation altogether. Mr. Sharma, I think, has got the point.
Yes, sir.
You get the point?
Yes, sir.
If the deposit is by Mr. Doctor
Or his
or
father.
by his father,
Yes,
it
sir.
means Doctor's client or by his father,
Yes, sir.
it would have a different connotation
Yes,
altogether.
sir.
But if it is by Mr.
Third
X,
party.
Y, Z,
Yes.
F, it would have a different.
Different issues. Yes.
Then Mr. Doctor will have to give one step ahead, have to go one more step ahead and make an explanation. But Mr. S. Doctor, Learned Senior Counsel, assisted by Ms.
I'm sorry, yeah.
M. Soikia, Learned Counsel for the petitioner. Also heard Mr. M. Sharma, Learned Counsel for the respondent bank. Hearing remains inconclusive. Also, Mr. Sharma, on the next date of listing, shall furnish before this court the records in original of the inquiry, including the statements of the witnesses deposing therein for both the management as well as the petitioner. So, register to list this matter when, Mr.
If it is before vacation, my lord, then of course, within this week.
This week may not be possible because we'll be 11th, there is a function, we'll be a bit tied up on
Or
9 and 10.
20th of
21st, Pari.
21st will be Wednesday. 22.
22,
Hello.
22, Thursday, 22, 120.
दे देना, अभी देख के दे देना, अभी देख के दे
For further hearing, yeah?
Yes.
Mr. Sharma, if possible, Mr. Doctor, his junior, whoever he nominates, kindly have
I
them
will
an
get
access.
chamber, your lordship, or
And
make a
Mr.
photostat
Doctor-
of the entire record.
What the things have.
Yes, yes.
Make a small note for me. on
Okay,
this.
Take.
But that's why I said it's an interesting issue. Yes.
My lord, last occasion, my lord, I placed 2 affidavit, my lord, the photocopy, my lord, as per.
Proceeding records entirely.
No, Lord, record is here, my lord, but lordship asked the 2 affidavit, my lord.
Nandita is the first one.
First one, my lord.
In my humble submission,
She made complaint, my lord.
as per allegation,
They are only on allegations. That is a past chapter now for you.
My lord.
So Nandita, this affidavit, which was there in the inquiry, you have not disputed this.
My humble submission, law is well settled. By an affidavit, marriage is.
Oh, forget that. You are a government employee. There is a latest decision of the Supreme Court also. A division bench judgment of this court
My lord.
that you cannot be expected to have this conduct and still be a member of the post.
Once, my humble submission, once a marriage is held valid, then question of bigamy will come.
Will consider.
My lord, that Gujarat High Court decision judgment is, my lord, I have one. That the affidavit marriage cannot be held as a merit as per the Hindu Marriage Act.
We are not on that. You have.
Once a marriage is held invalid, not valid, then how bigamy will be proved?
Forget bigamy. What about
The
your
charge is
conduct?
bigamy.
What about your conduct?
Charge is bigamy, my lord.
What about your conduct?
I'm not saying the conduct is, I'm saying what is charge is bigamy. Bigamy is required to be proved.
Where is that?
Yes, second time, so you have married, that is the law, rule is that bigamy, if the second time, married second time. Bigamy, if it is bigamy, then my lord, it is, I have no case.
Then your second marriage is also.
He has married fully and in the mode of love with the married. Then my lord, as per rule 15, if no member of the force whose wife is alive shall marry second time without permission of government, shall not second time. Then married should be, my lord, there must be a married, valid married. Affidavit marriage is my humble submission, not a.
Hindu marriage.
Yes.
Marriage in a temple is also
No,
accepted.
no, my lord, I have given judgment of the, my lord, 1962 Supreme Court, lordship in record. I am reading from the judgment of the Supreme Court, 1965 to Supreme Court has said.
Then your second marriage is also not a marriage.
Yes,
Not
none
a
of them
marriage
valid,
dialogue.
none of them valid.
So she is a nominee of yours.
Yes, that is another
Delete
aspect.
her. Delete.
Yes.
That is another aspect. That is another aspect.
Yes, ma'am.
That is not allegation and not before your lordship. My humble submission is
226
that,
power.
my lord, my humble submission is that I have placed with lordship the Supreme Court judgment. What is the valid marriage?
Okay. Where is it?
1965 to Supreme Court.
19?
I have given, my lord. Huaro Shankar Lekhade, State of Maharashtra, and one our High Court judgment also given. When marriage will be the second marriage bigamy. Para 6. Gandharva marriage designed and that is bigamy, Hindu marriage law.
This is a good report.
Para 6.
Of that Lokhande.
Yes. Now we may determine the essential ceremonies for a valid marriage between the parties are. It is alleged for the respondent that the marriage between Apil and Kambali was in Gandharva form, as modified by the customs prevailing in the Maharashtra, in the Hindu marriage law. The Gandharva marriage is a voluntary union of the youth and damned, which springs from the desire of the sensual inclination. It has at times it been erroneously described as an influential confusion. Now, view of this, I am not skipping it. At page 615, it is stated there are two ceremonies essential to the valid of marriage, whether marriage be it a Brahma form or Asura form, namely invocation before the second fire and the Saptapadi, that is the taking 7 steps, bedroom and the jointly before this sacred marriage. The marriage may be completed by the performance of the ceremonies other than those referred to as when allowed by the customs of the case if such parties along. It is not disputed that those essential ceremonies were not performed.
Okay.
That is Hindu Marriage Act, my lord, is a law is settled. For a marriage, there must be ceremonies and then it will be married. Or otherwise, by law, there must be a marriage certificate before the marriage register. None of it is here.
Now, you had executed a agreement with a lady. Right? And therein, it is said that you have married.
My lord.
Right?
My lord.
So there is a presumption that you also accepted the lady as a wife.
If it is a initial is bad and
Forget that. You are an
marriage is
employee.
void, then agreement is void.
Agreement is void, but you executed that agreement.
Yes.
And you
I have
leave.
denied this in the inquiry. My only question is that whether the marriage, whether is marriage valid, whether that can be marriage for
Anything
the
more,
person.
Mr. Medi?
My lord, that is, my lord, that affidavit is, there is his signature, everything is admitted, my lord.
Yes,
And
but
my lord,
denied
he is,
this.
my lord, his
His signature admitted.
this second
My-
wife also is
my-
the same man, my lord. This Ujjwal and Debasis, my lord.
Oh, he had approached Mr. Nath how to go about. He gave an
Yes,
his own register.
And
Execute an agreement.
and statement
My lord.
paragraph 8, my lord, this everything relationship.
My
everything is
humble
admitted.
submission is there must be a valid marriage, then my lord, his
But-
agreement is valid.
The Lanark Council for the parties at length. Hearing concluded, registry to list this matter again on all of last of all, yeah. a 31 for delivery of. I'll pass.
Lovely,
it.
lovely.
But I'll go through it once more.
Yes, my lord, yes. It is a dismissal from service, my lord.
60, 40.
My lord, that-
my lord,
that-
an-
that-
another-
my lord, lordship,
I'll remember
my-
what you have said.
That is your lordship. My humble.
I'll
one thing,
remember
my
what
lord,
you have. That
one
is-
thing, my lord. My humble submission, my case may be dismissed, my lord. I am not saying so.
Mr. Nutt, why I'm not passing the order today?
My lord.
I'll have to convince myself a bit more.
Definitely, my lord.
I'll accept that. If I
Yes.
come in your favor, I'll come in. your-
My lord.
And another law point is, my lord, so far this, he filed appeal, my lord, after my lord is on the, DP, my lord. And that there is another provision in the law, Rule 29, there is a provision of revision. Revision is there, my lord, after, my lord, this CRPF, my lord. That is not, a statutory, my lord, provision, my lord.
It is not, my lord, compulsory. May I prefer?
When the notices were issued in this matter, why was this plea not taken?
My lord, this law, that is the.
That's not the law. That is not a requirement. After an appeal, he can always come here.
Yes, yes.
That is, but.
May I
That is
prefer?
only a additional ground given. That is not the requirement of law. So please don't make that assumption.
My lord, oblige me. Please, my lordship.
Verification role,
My lord.
Tinu. What is his name? Tinu.
Tuntun Rai.
Tuntun Rai.
Tuntun Rai. Name is actually Farinder Rai, but alias Tuntun Rai.
But he seems to be a very hyperactive sort of a character. Many cases.
Well, only 2 cases. And when I, at that too, when I was a child, 10 or 11 years of age.
But the verification role requires you to disclose. You knew about it.
My lord.
You were subjected to arrest. You were then sent to juvenile board.
No, my lord. I was tried by the court of session and by the judicial magistrate first class.
So you were tried, you were in a proceeding. So why did you put no?
My lord, at that time, I was not properly guided. I had no some person.
Have you been arrested? No. Have you been prosecuted? No. Have you been kept under detention? No. Have you been ever bound down? No. And you are an employee. You want to be a member of a discipline force.
Actually, my lord, in both 2 cases.
Kendriya Vidyalaya onwards, there are decisions. Barring one or two, the normal is against you.
My lord.
That's the only issue.
That's only.
That is the only.
So that no that you have given is incorrect.
My lord, to that.
Now show me the decisions that you want to rely on.
So, my lord, I would like to put just one point. My lord, first judgment relating to his criminal case, regarding first case, it came on 3rd August 2008. Thereafter, my lord, in second decision, he was acquitted.
We'll hear you.
In both
That will
acquitted.
passed on.
We will hear you.
In both acquitted. In both acquitted.
I would like to point out just one point, my lord. Just one point, my lord. He was facing 2 trials, my lord. So far as the first case is concerned, that my lord will find at page 77, this judgment was passed on maybe 3rd of August 2008. This is the first case where he was acquitted. Then my lord may come to page 91. This is the second case. In this case also, he was acquitted. But my lord, in this particular case, date is very relevant. He was acquitted on 14 June 2013. But he was recruited in CRPF on 19/3/2012.
So at that time,
So at that time, the case was proceeding. When he has been appointed in the
recruited
CRPF.
on 19,
My lord,
19, recruited on 3.
2012. This is the only aspect, my lord.
Yes, Mr. Moria, what
Yes.
is the decision you want to rely? This is
So this I have given, my lord.
Madhya Pradesh High Court. Give me
Yes, my lord.
Supreme Court decisions.
My lord,
My lord,
I am
this is
having a Supreme Court decision.
But the point of my being juvenile, although was not raised in the trial courts, in the court of session as well as the court of juvenile my first class. But
Mr. Counsel, we are not even with your conviction or something. If it was the question whether you were convicted, you say no, fine. We understand. But here it goes beyond that. Here
No,
it is
there-
whether there was an FIR. Being a juvenile or being an adult does not make any difference. It's a question that you was asked to you. You should have given a bona fide answer.
my lord, probably I was of the belief that since my trial was in the name of Tuntun Rai, and my name
That will not be detected by anybody, but it is now established that you are alias Tuntun Rai. And you have also not taken a plea that that is not you.
No, that I'm not.
Then-
That I'm not taking on. My only point is, my lord, that I was a juvenile at that time. Even if I have not, I have suppressed that fact, then also, my lord, that is not a grave, such grave that I may should be terminated from the service, my lord.
Any Supreme Court decisions in support of your case?
My lord, can it be adjourned for 2 days?
In the given sets of facts and circumstances where suppression of relevant information is not a matter of dispute, there cannot be any legal basis for the court to interfere in the manner in the employee and in the manner that the employer be directed to impose any lesser punishment. And so accordingly, the appeal succeeds, so and so, set aside. So if the thing, the questions are, a question and answer is not subject to an interpretation, requirement of a process of interpretation. That's the end of the matter. Okay. But Mr. H.L. Moria, Lana Counsel for the petitioner, Mr. You are appearing for all the respondents?
Yes, my lord, I'm appearing for all the respondent.
CGC appearing for all the respondents. B. Deka. And hearing remains inconclusive. Mr. Also, Mr. Moria submits that he be granted 2 days time to place on record decisions in support of his contentions. Prayer accepted, registry to list this matter again on. You be sure, dear. 29/1/2026. Pada here.
Deeply obliged by you.
My lord,
Why was there no representation for the last till from 2017 onwards, Mr. Malakar?
my lord, person has been expired.
The repetition.
In the meantime, payment has been already, the retirement payment also, everything, all payment has been received by them from the government. And they are sitting only, I am for no contact. But in the meantime, I have contact them for the known persons. They have already called everything. There all payment has been received back. Nothing. But the thing is, there is a correspondence. But I mean, we have to give at least affidavit for the
How
court.
can this matter now proceed without substitution?
For the court. No, not they have not
When did
submitted.
this petitioner pass away?
That is also not my known to me.
We'll
But-
close
but
it.
they-
We'll
they-
close it as it has been become, the matter has been abated. No substitution is being made.
No,
No.
No, I have asked the Parthi now to
Likha.
give the.
You are Mr. R.K. Malakar or M.K. Malakar?
Yeah.
R.K.
R.K.
Malakar.
R.K. Malaga.
Learned Counsel for the petitioner. Also heard Mr. R. Dhar, Learned Standing Counsel, PWD, and Mr. D. Sharma, Learned Standing Counsel, AG, Assam. Also, Mr. Malakar, Learned Counsel for the petitioner, submits that during the pendency of the present proceedings, the petitioner has passed away. He submits that he had contacted the legal heirs of the petitioner and had required them to file application for substituting themselves in place of the original petitioner. However, the legal heirs of the petitioner have, by contending that they have received all the requisite pensionary benefits, are not interested to pursue the matter, he submits that he is not in a position to file an application for substitution of the original petitioner by his legal heirs. So, in view of the above, the petitioner no longer being alive in the present world, but no longer being alive, the present writ petition stands abated. Accordingly, the same is closed. We are not saying anything further.
My lord, what remains, the main crux remains, my lord.
Main
I
crux
have
remains.
objection, my lord.
Now you can't recover it also.
We'll recover it from family pension, my lord.
You start doing, come back, they'll come back, then we will see.
Yes, my lord. My lord, there is a.
See, that is why I told you when in the morning that I was not inclined to dismiss this writ petition.
My lord, now the thing is that my lord pastor closed the, I have no issue. There is an interim order that has to be vacated.
Interim order passed earlier stands vacated.
My lord.
Mr. Malakar, they take any action, come back. We are here.
think, my lord, they have received the pensionary benefits. my lord.
His instruction is different.
Today morning, I have taken the instructions. my lord. He said that
If they are satisfied, that is enough. Mr.
Well, I have
Malakar has
taken-
said that they are satisfied. What can he do?
that's why I have
Can
not
do
made my
nothing.
submissions, my lord.
Huh?
That's why I have not made my submission.
It's better to keep quiet sometimes.
Thank you.
My lord has already heard this matter, my lord, earlier in length. Only point, my lord, that is to be determined, my lord, whether from the counter of the respondents, my lord, the writ petitioner's job is found to be less arduous than the private respondent, my lord. That is the point of that is the point of we decided, my lord. If that is no, my lord, then my writ petition has to be allowed.
Okay. Any further submissions to be made?
Yes, my lord, that last time also I have made a submission regarding the recent development, my lord, that is in my affidavit in opposition, in my reply, my lord. From 23 onwards, they have, it's a new advertisement, my lord, page 67 of my affidavit in reply. As per this new advertisement, my lord, they have kept the rate pay similar, my lord, 6,200.
Grade pay of the post of
Modular 4.
Modular 4.
Yes, my lord.
Hmm.
Pay bin is similar, grade pay is also similar.
Similar to? Are you getting that grade pay?
No.
Where
The
show me
private
advertisement.
respondent is getting 7,200, my lord.
Where is that advertisement? Page
At
2?
page 67 of my affidavit in reply. Annexure 13.
You are a diploma holder.
HSLC with certificate.
Certificate, not a diploma.
Not a diploma.
Annexure 13. Okay. Let us see that.
Yeah, my lord. Page 68 is the relevant person.
Hmm.
Serial number 23, my lord. If qualification HSLC with training in modular from a government recognized institute, pay bin same, my lord, and grade pay 6,200. So I've been paid this 6,200 as of now, but the private respondent, my lord, Just because he's a graduate, my lord, he gets, my lord, 7,200.
Okay.
And I've also given a compilation of the judgments, my lord, that I've relied. Mostly, my lord, the Ranjit Singh judgment, my lord.
Old one. Dinesh KK and all those
Yes,
things.
yes. But one thing is relevant, my lord, because just put one line, just line, one paras, last para, my lord, para 9
Of?
of the Ranjit Singh judgment, my lord.
Hmm.
May I read, my lord? There cannot be the slightest doubt that the drivers in the Delhi police force perform the same functions and duties as other drivers in service of the Delhi administration and
Got
the
it.
central government. If anything by reason of their investiture with the powers, functions, and privileges of a police officer, their duties and responsibilities are more arduous. In answer to the allegation in the petition that the driver constables of the Delhi police force perform no less arduous duties than drivers in other departments, it was admitted by the respondents in their counter that the duties of the driver constables of the Delhi police force were onerous. What then is the reason for giving them a lower scale of pay than others? There is none. The only answer, this is important, look, the only answer to the respondent is that the drivers of the Delhi police force and the other drivers belong to different departments, and that the principle of equal pay for equal work is not principle which the courts may recognize and act upon. We have shown
You are
that.
getting that 6,200 now.
Yes, yes, my lord. Just the last line, my lord. We have then shown that the answer is unsound, my lord. The clarification is irrational. And what in my case, my lord, kindly come to my lord, page 41, the DME's opinion, my lord. He says,
Page?
page 41 of my writ petition, my lord. This is a, my lord, answer to a query from the Health Secretary Health, my lord. He says, with reference to the subject and the government letter cited above, I have the honor to furnish herewith following information as sought by the government by letter so and so. Yes, the work function of artist, modeler, and artist projectionist are same, but photographer is different. Number
Now
two.
that you say that he is the other one, he is getting 7,200.
Yes, sir.
That is in terms of the pay commission recommendation.
Yes, as per
Because higher qualification, that pay was.
Yes, yes.
What is the error in that?
Lord, apparently, my lord, yes, there, as per ROP, he has been given. But, my lord, thing is that there are two, my lord, cases pending in the division bench on the same point, my lord. So one is, my lord, Puranjali Deka and other 18 others, my lord. WPC 6306 of 2024.
Means what happened there? Writ petitions are pending.
Yes, my lord. They have challenged the ROP 2017, my lord.
On the point of modeler.
Yes, no, not modeler. They are, my lord, nurse.
That is different. What about modeler?
Modeler, there is no pending.
So if the rules envisage
Yes,
two salaries,
yes,
which is again permissible
yes,
on the basis of qualification.
yes, my lord.
So you are getting 6,200, the diploma scale.
Yes,
Diploma scale.
non-diploma, yes.
Non-diploma scale.
Yes, ma'am.
And it is getting 7,200, which is the
Yes,
diploma scale.
graduate.
So what is the error?
The error, my lord, in the same cadre, my lord. They are out of the
Same
same.
cadre, there are decisions of the Supreme Court which says that if on the basis of the higher qualification, if a thing is given,
Yes, my
like
lord.
BSc nurses are given 8,300
Yes, my lord.
in the medical colleges.
Yes.
GNM nurses are given at a lower stage.
Yes, my lord.
They are drawing it. Single benches have not here. Division bench, I think the matter is pending.
Yes, matter is pending. That is why, my lord, otherwise the principle, my lord, they have challenged ROP 2017 as well as
But
2010.
in your case, there is no challenge.
I have not made a challenge, my lord. I have not made a challenge.
You make a challenge to that.
But going by the decision, though, whatever I have cited, my lord, it becomes.
No, you
very-
show me
Yes,
that there cannot be two scales of pay
exactly, my lord.
for a single post.
Yes, my lord, I have also cited one judgment of, just for lordship reference, my lord, a Gujarat High Court judgment, my lord. That is,
Gujarat High Court.
yes, my lord, just for reference, my lord.
Citation?
My lord, I have given the copy, my lord. The citation is not. This is,
Delhi High Court. Nishan Chawla.
yes, Delhi High Court is also there, my lord. Ishan Chawla is there. But before that, my lord, Bin Rajya Patri Technical Karmasari Mandal. versus State of- Yes, my lord.
Hmm.
Herein, my lord, it says, at para 8, my lord. Before proceeding with the matter, the fact which is very clear is that the recruitment rules are framed under Article 309 of the Constitution of India, wherein the qualification for appointment of planning assistant is degree in civil engineering or diploma in civil engineering. When the recruitment rules specifically prescribe both the qualifications, in my view, having different pay scales only on the basis of educational qualification is contrary to the rules, which are statutory rules. In the view of the matter, the distinction made by the state government on the recommendation of the high-level committee only on ground of educational qualification is contrary to the statutory rules. When both the persons holding different qualifications are appointed under the same rules and are holding same post, the decision of the state government in prescribing two pay scales for the same post is contrary to law and violative of Article 14 of the Constitution. So this is one view, my lord. And my lord, there is the Delhi High Court judgment.
Nishan
Chawla. Yes, my lord. Para 34. It has relied the Federation of All India Customs and Central Excise Stenographers decision, my lord. And while relying that, my lord, there is quoted that decision at paragraph 34, sub clause 6C, my lord, page 22. That's the relevant portion. While equation of post and equation of pay are matters primarily for the executive government and expert bodies like the pay commission and not for the courts, where all things are equal, that is where all relevant considerations are the same. Persons holding the identical posts may not be treated differently in a matter of their pay merely because they belong to different departments.
This is not exactly the point. Anyway, we'll see.
Yes, my lord.
But Mr. R. Chakraborty, learned counsel for the petition, heard Mr. P. Upamanyu, learned.
M. Bhuyan, Lordship.
Sorry, M. Bhuya, learned Planning Council, Health and Family Welfare Department, appearing on behalf of Mr. B. Gogoi, learned additional general for the respondents. Also heard Mr. So-and-so Architect, learned counsel, appearing for the respondent number 4. Hearing concluded, so judgment reserved.
All right.
Yes, you are for the respondent number 4.
Yes, my lord.
Okay, what is your submission?
My lord, I already been dismissed from the service, my lord. I have
Already dismissed.
My lord.
And the post has been re-advertised.
I have no knowledge, my lord. Might be someone holding the charge. my lord.
Now, what would happen? He is dismissed. Why were you dismissed?
My lord, there is some allegation that I took money to issue.
Not because of the.
No, my lord, no, my lord, not related to that.
Yes, madam, what should we do now?
We need to take the instruction on this lordship. Lordship may post it on day after tomorrow, lordship.
The learned counsel for the respondent number 4, Mr.
KM Hassan on behalf.
KM Hassan, learned counsel, KM Hassan submits that During the pendency of the present proceedings, the respondent number 4, who was appointed as the Gaon Pradhan for Dalani Juria lot oblique Kisam, was dismissed, was terminated from his services on account of certain allegations being leveled against him. He submits that accordingly, the respondent number 4 is no longer functioning as the Gaon Pradhan for the Gaon Pradhan. Also, Ms. M. Bachchaji submits that she would receive her instructions as to the steps taken by the respondent authorities after termination of the services of the petitioner hearing. Registry to list this matter again on Kundina Free Essay. 29th.
My lord, only one thing, my lord, this present petitioner's earlier this petition was dismissed on 13/8/2017, my lord. Subsequently filed the IA, my lord, then restored it, my lord.
That's it.
Obvious, my lord.
Item 13, just two judgments, my lord. Otherwise, it has been concluded. Whether on basis of educational qualification,
that you will
only that part, my lord. I have given the para also, my
The respondent.
lord.
Sir, I have obtained instruction from the client, my lord. If the punishment is restricted to two increments, my lord, no cumulative, my lord, the lordship may consider that, my lord. Two increments without cumulative effect, my lord. He is a SI only, has not got any promotion till date due to all these things. Suffered a lot, again a new proceeding, my lord, I made him understand.
See, after some time, Talukdar Dari.
An inquiry report I have seen, my lord, lordship will find number of documents have been relied upon, my lord. The list of documents was also not there. These are the number of infirmities that I pointed out, my lord.
So if the infirmities go to the root of the matter, we'll have been left with no other alternative but to interfere.
Hello.
If we interfere, there is nothing. But if we come to a conclusion that no, there is materials, then you say 2 increments without cumulative effect. Okay, after.
Yes, sir. Yes.
May I please your lordship, kindly matter may be fixed on 2 p.m.
Wait.
after lunch.
My pleasure, lordship. Lordship, as per your
1880. Yes.
Your lordship,
Where are your decisions?
lordship, my senior is on legs in another court.
Oh, he seems to be very busy today.
Lordship, at 2 p.m. lordship.
Right.
My pleasure, lordship. Lordship, as per your direction, lordship, we have prepared a short note, lordship. Lordship, may I kindly have a look at this.
In short note at the.
You thought 21 is enough. You did not know that it will be a very tough competition. It will go up. So you kept it at 21. You did not.
Didn't know.
Have you got the copy? Have you got a copy of that?
Yeah, I just received it.
You go through it. We'll take it up in the second. Mr. Das seems to have put a rope around us through this on the technical aspects.
Yes. Technical aspects.
If that is true, then it will go to the root of the matter. But was a statement under 161 recorded of this PW 13? Azam something, Azam.
That instructions I don't have, my lord, here. But the charge is that
But
I
the,
exerted pressure.
the IO,
Huh.
IO's deposition is that Azam something, Azam. Who
Yes,
was the,
IO deposed, yes, IO in his statement, he
did
deposed
he
that during
exhibit any document to that effect? No, only statement.
the statement.
Second of it. We'll have it.
Yes. Much appreciated.
May it please your lordship, on the last occasion, the matter was.
We'll take it up. Now we'll take it up in the second half.
Second half, lordship.
Possible.
Second half. We'll have it. We'll come back at 2. We'll take the matters, rest matters at 2.
Oblige your lordship.
It serially low level. Judgment. Serial coalition.
Lordship, I have a prayer, Lordship. In respect to the item number 9, Lordship, I am here since morning, Lordship. The petitioner counsel is not here. Otherwise, in second half, Lordship, one hearing matter will be taken in court number 10. Then
We'll
Lordship may
have it on some
accommodate.
other day. Don't worry.
Lordship may accommodate me. If I will be there, then Lordship. accommodate.
M. Sharma matter. S. Doctor. Sorry, dismissed. The trial will proceed now. Madam, you will get, there are some corrections, you will get it only by day after.
Yeah.
So kindly apply for that, you will get the copies. To all of corrections. Bottom page to change. So. The payment of fine. We have upheld the conviction, but the punishment has been modified. We have removed the punishment, but the compensation amount you will have to pay within 2 months or undergo repression for 6 months. Same thing, my steno who has typed it out, she is on leave. So it may take a day or 2 for uploading. I guess.
Deeply obliged.
The judgment and order under appeal is not interfered with. The revision petition is dismissed. petitioner to appear before the trial court within 1 month to pay the compensation amount.
Obliged.
The penalty imposed is not interfered with. Writ petition stands dismissed. We have only gone with the undertaking. It was done. Sorry, couldn't help it. He should not have given that undertaking. That shows even temporary misappropriation.
Otherwise, there was procedural lapse.
Maybe, but once he has admitted to the charges, why we should go into those? The impugned award is set aside. Writ petition allowed. Writ petition stand allowed. We have interfered with the orders.
Obliged.
The impugned order is not interfered with. Writ petition stands dismissed. We have discussed the 89 thing section. We have held that seniority cannot be reckoned before 23/8/2005, 2005. Accordingly, the writ petition stands dismissed. Bonus, New Year bonus. Entire salary directed to be released.
Obliged.
Area salaries for the period when you're out,
Yes.
we have said.
Deeply obliged.
But initially I was against you. We have dismissed the appeal, directed the learned trial court to proceed in accordance with law. Writ petition dismissed.
Obliged.
We have allowed the writ petition. We have directed for consideration of your case in accordance with your seniority for promotion as supervisor.
Deeply obliged.
Writ petition dismissed. Hello, Humayun. Yes. Where is Mr. Borua?
He was here, lordship.
Okay, get it. We'll take it up after 2 items. Because we only want a clarification on that aspect.
Lordship.
Ah, Mr. Burwa is here. Yes, Mr. Burwa. What did you find?
May it please, your lordship. Lordship, so cause notice given, then reply they have filed. Charges we have framed, charges we have served.
Fine,
After
you-
the,
that's
after
that-
for the list of witness was there, all the notices were being sent to all the witnesses, lordship.
No, no.
Thing is that the notice to them, yes, to him. There's no such notice provided to me where I can say the notice has been served to me. Because after that,
So in the inquiry,
yes,
the inquiry officer has not served any notice about the
I
inquiry.
have not got any office copy of a notice which shows that notice has been served to him. After that, but the notice served to other people under that copy to notice serves XYZ lordship notice served to them under that copy to that descended acknowledgement was been given to him. Acknowledgement was been given to him. Now after that lordship, on the last occasion, as per this thing, I telephoned them that whether you provide something that to know that at least show something that whether you have given that they directly given notice to him or then one message I have received that was in negative lordship, that was in WhatsApp message that which shows I have shown to him also lordship, my friend Jogan Hende.
Mr. Burwa, you tell me, I believe you.
Yeah, that which shows lordship the notice, direct notice to him was not been sent. That is only a WhatsApp message.
Okay.
After that lordship, the
In
last
your records, there is a notice sent to there is a document showing notice sent to the witnesses.
notice sent to the other people.
But whether that notice was also served on him.
Yes,
Lordship,
yes,
that was
yes, 100%.
I have already annexed in my writ petition also.
Yes,
Where
yes.
page?
Page 57, lordship. Annexure K, lordship.
The lordship may see these notices, copy to Diganta Borwa. That might happen.
Page 57, Annexure K, lordship.
He very well know that the date of this thing. Copy to Diganta Borwa.
And after the inquiry, was the inquiry report given to him?
No, lordship.
That inquiry report given to him or not, that was.
The record?
Lordship, I can say the order of the inquiry report, the order of dismiss, that was been communicated to him.
That is communicated fine, but whether before that.
Inquiry
the-
report, Lordship.
Ah.
Look, that Lordship, today I specifically, Lordship, I cannot tell before this court, Lordship, whether that. Otherwise, the
inquiry
order.
report
No,
was-
lordship, only the order. of
Only,
dismissal
but the
was given.
order of dismissal was
Have
being
you taken
communicated.
that plea in your appeal?
Lordship. I have taken that particular plea in my. appeal also.
71 E and F.
ENF, lordship.
Where is your charge sheet?
Lordship.
What happened to the criminal case?
Lordship, that is pending, lordship.
Charge sheet file.
Charge it file, lordship. Charge not yet framed, lordship. Order of dismissal is at page 63, lordship. Annexure L, lordship.
Lecture
L, lordship.
3. Okay. He'll be under suspension. We are interfering with the inquiry as well as by the order of termination.
Dismiss this.
He'll be constituted to be under suspension.
Lordship.
Institute the
Press.
no, that same inquiry from the stage of
Yes, Lordship.
inquiry.
Yes, Lordship. Mass of blessings. Mass of blessings.
Allegations are very serious against you. Can't let you go off like.
Applied a copy of the inquiry report.
No,
Yes, yes.
inquiry itself.
Lordship.
The inquiry has to be redone because he did not get an opportunity.
That's
let-
true.
let-
That's true.
Yes, you don't look to be very happy. What do you have to say?
It is apparent illegal, Lordship. They may,
That
but he may
illegality,
be reinstated, Lordship.
no, we will put you under suspension
In this regard,
and they will conduct that inquiry afresh and thereafter complete the procedure.
I want to place some judgments of this honorable court also, Lordship.
Give me.
He has been reinstated, his Lordship.
FRSR fund was.
Similar set of allegations, Lordship. Raised us. WPC number 2555020.
Okay, we'll consider it. But
Recent judgment of Mrs. Madhya Pradesh High Court. And Lordship, one more thing, Lordship, that WPC 2555020.
you read this. FRSR 54A, 2, 1 and 3. পুনৰ উঠিব লাগিব। Anything more, Mr. Borwa? Nothing?
Brother may.
Lordship, one more thing, Lordship.
Hmm.
Kindly peruse the order of dismissal, Lordship, as page 63.
I'm
Lordship.
interfering with that.
Lordship,
I'm interfering.
my humble prayer is to let the petitioner be reinstated in service.
With
Lordship.
this nature of allegation against you and the post you are to be holding,
Lordship,
we will fix a time frame for completion of the inquiry and we'll ensure that they do it. Don't worry about it. We'll fix a time frame. Only an inquiry and the thing, you also cooperate with them.
along with back wages, Lordship.
That will be subject to the final decision in the inquiry. If you're exonerated, you get back everything. If you're exonerated, you get back everything.
Till then, I may be allowed to get my subsidy allowance, Lordship.
Subsistence allowance, from the date the dismissal order is passed, we are interfering. From that day, you will be deemed to be under suspension. You will be released with the subsistence allowance from that day, not from today, from that day. Because I'll have to put you back into service so that then only I can direct them to conduct that inquiry.
Reinstatement part, Lordship.
Reinstatement not possible. Reinstatement subject to the outcome of the appeal. And Mr. Borwa will pass an order, ensure that the proceedings are completed within that time.
90 days time may be given. Lordship.
Whatever is.
90 days enough.
Lordship, whether the judgment will help me. That
I'll consider that.
can it
If I
be-
find that
Oh,
I have to follow that, I'll follow that.
Oh,
Don't
look,
worry.
two more judgments I had.
Lordship, I think the election ongoing list is coming, Lordship. So
Forget elections. Man's right is involved. You will have to. We are passing this order on 20th. We are passing this order on 20th, 19th. On 19th, I'll not do it. 20th. 21st, we'll pass this order. And elections would be in sometime in April.
April.
That means you mean to say every activity of the district commissioner's office is stalled. Cannot be. We'll give you some time, reasonable time for that.
Lordship, I may be allowed to place some judgment, Lordship. I'll provide.
You can give it to her. But the parties at length, hearing concluded, register to list this matter again on 21,
Lordship, please.
1/2026 for delivery of orders.
Possible.
Oblige.
Any judgment you have, you give it to her.
Lordship.
মুখ আজি বোলে কলে পুনৰ উঠি গুচি গলো মালাকাৰে কলে ছাৰ আজি আছে
Lordship, for time being, Lordship, he is in leg in court 14, Lordship. For some time. Lordship.
I have many corrections to make. As paid for by the Land Council for the parties, registered to list this matter again on
Day after tomorrow, Lordship.
19/1/2026. So these 2-3 days we'll not be able to do it. 19? Or keep missing. Mr. Kolta, we'll hear this matter. There are few other matters. We'll just get over with that and then. No, not today. Reference is tomorrow. I was also under that impression that it is today. Mr. You had problem. Mr. K. Gugwe has a problem. So we'll have it on some other day. He made a mention before going. On the prayer of the Land Council for the parties, registered to list this matter again for hearing. Again, for admission on 30. You make a small note
Yes, Lordship,
of the
because
comparisons. What you want to,
it is confusing.
what you want to in support of your case.
Yes,
Just make a small.
Lordship. Lordship, can it be on any other date than 30th because?
5.
Not-
5-2. Yes.
Lordship, on the last occasion, my lord, 4 questions cropped up. Whether he was given the opportunity to cross-examine, my lord. Secondly, defense assistance, whether he was provided or not.
That
And-
is
and the-
criteria. Cross-examination, enquiry report, and why a PO was not appointed.
Why the PO? Why the PO is not appointed, that is, that.
So it's not appointed.
Not
Okay.
appointed.
Then,
And cross-examine, lordship, he declined to cross-examine in
so
all
that
the
is what I
cases.
want.
In all the cases for, I'll place it.
That is
under-
mentioned in the inquiry report, my lord. That defense assistance was also given, not taken, and then
And the
These 2
prosecution
points,
opportunity was given.
These 2
It is
points.
mentioned in the, I had no opportunity to rebut all these things because it was not given to me. I could not give representation. Let that as it may be, my lord.
Oh, no, if that
report to go take it as.
opportunity of cross-examination was given to you, you have not accepted it.
My pleading is
cannot
that,
be-
pleading that it was not given. Now, had the inquiry report they had given me, I
No,
could
no,
have.
the deposition we'll have to see, na, your signature would be there.
Yes. it
Show
is
me.
there. Deposition ke ready.
Depositions.
My lord.
The deposition it will be there.
এই তো তারপরে। ওটা তো আরম্ভ করে দেব।
What is the name of the petitioner?
My lord,
Bhaskar-
Bhaskar Jyoti Nath, my lord,
Oh,
is given.
In all,
so that gone.
And list of document, my lord, I've taken a specific plea, my lord. That was not given with the charge sheet, but your lordship goes to the inquiry report, number of documents, my lord. Some
That
messages.
number of documents were produced by the witnesses.
witnesses.
Where have you taken a plea? Have you?
Ah, yes, my lord, in the
No, 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 in the inquiry.
inquiry.
In the inquiry, when these documents were produced, have you taken a plea that these copies were not given to me?
That possibility. He did not, my lord, he is a assistant, my lord, sub-inspector only, my lord.
Sub-inspector, he is the one. 302 case also he can inquire.
Yes.
Ah. If he was a peon, I would have understood.
But lordship, some documents which are not mentioned and relied up by the inquiry, that is not permissible in law, my lord.
Okay, show me the documents which were.
Well, the inquiry report, lordship, kindly see. Number of communications, messages, voice
Inquiry
messages and
report
all.
is
my lord.
flag marked there, my.
Hmm?
Report is flag marked.
No, it's here.
That is also one of the grounds which I have taken, my lord. List of document, my lord, if they rely upon that has to be given to me, my lord. I should know what documents they are going to rely. Even my application, even my reply, whatever.
The first, the conclusions are there. EL application, sir, 27/1/2013 to 6/1/2013. That is your document.
My document.
Your nomination for training, that is already available on record. So that also need not be given. It's there. No prejudice is caused. Your prayer petition for not appearing in the training program, that is also your document. Your detailing for pilot duty, PM duty, that is also a document known to you. So these are the only documents which have been taken. What prejudice has
My
been?
submission is that whatever they're going to rely upon,
That
there may be
documents
hundreds
are,
of documents which are going to be relied, that should be given in the list of
no,
documents.
that documents have come
There is
on
no
record
list, my
through the
lord.
inquiry, through the witnesses. Evidence of the witnesses. You did not cross-examine them.
My lord.
And these are documents which are there in your own possession, your own documents.
I don't know what the inquiry officer will be relying upon.
Mr. Chakraborty, in the inquiry, when
That's
these
my lord.
documents were being produced, you
Even
knew
that-
about it.
There may be hundreds of documents.
No,
at
they have
station.
done it.
I don't know what way, in what manner they have used it. I don't know.
Okay, where is the charge sheet?
Charge sheet, my lord.
Because
That page 21, my lord. I'm just making my submission, my lord.
here there was no list of documents.
No, my lord. That is mandatory under the law, my lord.
Now this detailing, you're detailing for performing the pilot duty of the former Prime Minister of Bhutan.
Yeah.
This was a document known to you?
The lordship is very correct, my lord. Some of the documents mentioned which possibly was in my domain, my lord. I also knew about it. But the requirement of law is that if it is going to be used, that should be.
No, that was through the witnesses, it was coming on record. You had given an opportunity to cross-examine. You have not said anything. And you have signed there.
Cross-examination part is there.
Decline. You signed. That means the evidences you
My lord,
accepted.
That I have accepted. Since I have signed it, my lord, I cannot say that I was not given opportunity.
Now your only case is PO and
POIO and that.
Enquiry reports.
And
and
one,
the
one,
inquiry report not given to you.
my lord, lordship, kindly see for a moment, my lord, the mindset of the inquiry of proceeding, my lord. Page 26, my lord. That I have not placed before lordship. Lordship, kindly say the reply of show cause notice submitted by so-and-so, so-and-so, so-and-so in connection with so-and-so against him is not satisfactory, so-and-so appointed as so, he will inquire and submit the finding within 1 month. Now he complete and give it. And
That cannot be. But now page 27.
27.
Proceeding fine. Charges established. But what about page 27?
27, my lord, yeah. 27, lordship, kindly see. That I have submitted before lordship. My lord, Relinkit is a poor officer in terms of the image among district police as well as the public. They are.
Mr.
All big.
Talukdar,
Man,
where are the charges to this effect?
Yes, my lord.
does it too?
The charges to this effect about his negligence, about his character, his performance in the charge sheet?
Charge sheet, that is.
Then
it
how
is
can
not
you?
there.
First line and the last line of first paragraph we accept, but the middle portion cannot be accepted. So it is a case of proportionality now.
My lord.
And one of the charges against him is
Is
that he was
Sir,
unauthorizedly absent.
while
Right.
in escort duty.
No, that is second one. First one is that he was unauthorizedly absent
Absent finding.
on 25/1/2013 and resumed on 27/1. Then again, he was absent from 27/1 and
6/2.
joined on 6/2. See, unauthorized is when there is no explanation. He had given an explanation and he was not keeping well, whatever it is. You had not taken that into consideration.
We have not taken those consideration of those.
That cause given. If the cause is genuine, it cannot be an unauthorized absence.
Their second and third charges, my lord.
First and
Second.
second. Third one, yes, duty.
And second also, he could not attend the training. He did not immediately report it to his senior authority. Instead, he sent the application to somebody else.
Okay.
Lordship will find it there.
We are keeping the options open.
The cumulative part goes, my lord, my only submission, my lord, cumulative part goes, my lord.
Then you get back, you're in the free.
My lord.
Cumulative part, if we, on proportionality, we find
Well,
that the
yes.
cumulative part is too
That-
much, we will interfere with that.
My lord.
Yeah, good.
Record to Rahido. To Rahido. But Mr. B. Chakraborty, Learned Counsel for a petitioner, also heard Mr. B. J. Talukdar, Learned Senior Counsel, assisted by Mr. P. K. Medi, Learned Counsel, appearing for the respondents. Mr. Talukdar has produced the records of the departmental proceeding. The same is taken on record. Also, hearing concluded. Registry to list this matter again on 27. 27/1/2026 for delivery of orders.
27. No, hold it.
Yes, Mr.
No, DLC recommended and pending before SLC. This is the present facts of the case, my lord.
When was the DLC recommendation?
DLC recommendation, my lord, 6/2/2023, page
6/2?
16. 6/2/2023.
Have you applied in pursuance to that advertisement?
No, my lord.
Can't consider.
Because it's pending before SLC still date, my lord.
Where do you get that?
Yes, my lord, because that is recommended and as per their instruction, my lord, still they are not denied, that it was rejected or not. Their
Page
status-
16.
Page 16. Relevant portion, page 18, my lord. In middle, my lord.
Anything more?
My humble submission, my lord. Till date, my lord, they have not placed whether it is rejected or it is still pending. This is one aspect, my lord. Another aspect, my lord, I filed an additional affidavit. I am seeking to benefit of that single judgment, my lord. That was.
That your affidavit in reply,
Affi-
judgment you have an
Affidavit, additional affidavit, my lord.
additional affidavit, Abdul Qadir Bakshi.
Yes, ma'am.
Anything more?
Also, my lord, I have that, so my lord, I may be allowed to, if required, my lord, still there is pendency is there, my lord. My case is pending before SLC. So this right, I have accrued that I may be placed before, pursuant to that notification, my lord. I may be allowed to apply, my lord.
We will not open a Pandora's box.
My lord.
That application was there, it was open to you to apply. We would have, I have closed many petitions.
My lord, since the case is pending, my lord, since long, and it is pending, my lord, since 2023.
You have not challenged 18/9/2024 in this present writ petition, have you?
My lord, I have filed this writ petition in the year 2020.
That is what.
Until date it is pending.
Now you come to the Abdul Qadir.
My lord, we are waiting for the final disposal.
Okay, you
Waiting
come
for
to
the-
Abdul Qadir Bakshi's case.
Yes, ma'am.
Para 9, page 30. See, I can only understand this judgment in the way it has been written. I can't go beyond it. What is written in para 9? Read. In view of the that are pending as on today, 3/4/25. Till here you are covered. Which have put to challenge the impugned notification dated so and so are to be decided as follows. So it is only in respect of cases wherein the challenge is to the 18/9/2024 judge, OM. Beyond that, we can do.
My lord, this is one aspect, at least, my lord, considering my case in the present circumstances, at least.
And see, the
at least I have the-
recommendation.
My lord, I have the right to apply, my lord, because the case is pending and till since 2023, they have not placed even the present position, my lord. Repeatedly, they were, respondent were told, my
And
lord.
this is no recommendation.
This-
What is this recommendation? There is no recommendation against a post. Says that in other department, if it is there, that cannot be a recommendation of the DLC.
My lord, this still, my lord, it is.
That cannot be. That cannot be. And see, when did you submit your application? Father died 2016.
Yes, ma'am. And that, my lord, that recommendation was made pursuant to the order of this honorable court, my lord.
So you submitted your application on 18/4/2018, right?
My lord.
That was considered in 19.
Yes, my lord.
16/12/2019,
Yes, ma'am.
right? We'll examine it in that manner. Now, Achyut Kumar Das is a judgment which is still holding the field.
My lord, that was not considered. Earlier, I was rejected, my lord. I approached before this honorable court.
Rejected?
Pursuant to that, my lord.
Okay. What is clause 10 of that judgment says that if an application remains unconsidered for 2 years for want of vacancy, that will lose its force. Right? Let us hold it that 18 this application, 19 this was considered. There was no vacancy. 20, 21, 22, 3 years, 4 years. Then your application came to be considered on in the year 23. And therein also it is no vacancy. End of the matter.
My lord, that recommendation is pending before the SLC. SLC has
This
not
is
decided
yeah,
yet.
I'll put
Whether
it in.
that case may be decided.
I will put it here. Will
My
not
hum-
trouble the government. I'll put it
My
here
humble
that
submission.
this is no recommendation at all.
My humble submission, my lord, I may be allowed to apply pursuant to that. At least then they may be decide, my lord, my case may be
The
rejected.
last
or
date is
accepted.
already, last date is already.
Lordship.
My lord, still, my lord, the recent case,
It was, there was no bar therein that
Yes,
because of pendency
those
of
who
case you
cease-
cannot apply.
They are asked to apply it.
And I can't ask you to apply because I can't go beyond the decision.
my lord,
that they got
since
in
the
the-
matter is pending, my lord, since the matter is pending, so cause of action still survives, my lord. So pursuant to that, my lord, I may be allowed to submit, my lord.
Dismissed. I'll pass the order. I'm sorry, can't help it. Yes, Mr. Mahmood, you wanted to place some judgments.
Yes. The other day I have told this story. The matter was that petitioner and one Meera Sharma was appointed
Meera Soikia.
together, Meera Soikia was appointed together by common order. Then Meera Soikia, both of them were appointed as staff nurse.
The facts we know, Mr. You give me a judgments.
The question is this, Lordship may. That it is 22/18 SSC 1/4. Your Lordship would see para 10 onwards.
11.
This will not apply because this is in relation to pension.
No, here is question of pension or notional promotion and thereafter pension. has been.
Oh, that is different. Yes, then next one.
And the 3 years back wages were also given.
We have taken it, don't worry. Then
And then our High Court decision is that
Krishna Kumar Sharma.
yes. Krishna Kumar Sharma Para 33 may be seen. In accordance with the directions issued above, the respondent number 2, 3, and 4 would initiate necessary steps for ensuring that the difference of pension and other retirement dues are paid to the petitioner as per admissible rules by reckoning his notional portion. So this is fully applicable in my case. And for delay, a person cannot be denied from his or her right. Regarding delay, we have explained. The delay point, the other judgment which I have given, para 10, it is stated in case of pension, the cause of action actually continues from month to month. That, however, cannot be a ground to overlook delay in filing petition. So it cannot be overlooked.
Any further judgments, Mr.
So this, the other day I have already talked.
You have given, be waiting for, you wanted to place some further judgments, so. But Mr. M.E. Mahmood, Learned Counsel for the petitioner, but Ms. Sri Bora, Learned Standing Counsel, Health and Family Welfare Department. Hearing concluded, registry to list this matter again on 28/1/2026 for delivery of orders.
Obliged.
Yes, Mr. Bora, what do you have to say?
Lordship, if I have to be very honest, Your Lordship, otherwise, yes, Rajendra Yadav will apply. But apart from that, thing it suffices
You're
because
giving him a very easy walkover.
just
Don't do
just to
that.
actually cut everything short.
No, don't cut
But
it
at the
short.
same time, Your Lordship, he
We have serious doubts about these propositions.
and also with regards to the
Yes, Mr. Das, he is accepting everything easily. That is not called for.
No, he is accepting only to the extent of Rajendra Yadav.
Rajendra Yadav.
Milord, I am going a bit ahead of him. I would say that this entire inquiry report is absolutely perverse, Milord. What is the
Anything more?
evidence?
Hello. But Mr. H.K. Das, Learned Counsel, but I was against you on the first day.
I understand, Milord.
H.K. Das, Learned Counsel for the petitioner also heard Mr. D. Bora, Learned Counsel, appearing, Learned Government Advocate appearing for the respondents. Hearing concluded, a registry to list this matter again on.
It will be this. Milord, there is one judgment with regard to Milord back wages and area.
If I hold this whole thing to be bad, then it automatically follows.
Yes, even then, Milord. Justice Nariman's judgment, Milord. Hey, Shobharam Rathuri. 16 out. Who fault he has been? Look.
Registry to list this matter again on. I strike a DD. 27/1/2026 for delivery of what?
Fine.
Oh, by strike a DD.
Deeply obvious. Much.
We are allowing it. Yeah. Judgment 27. 27/1. Paki Sukhekh. Before. No, yes, I forgot everything.
Yes, Lord. In the case,
I only remember BLO Dispur and BLO Amingaon. Baki I forgot. Give me the facts.
so in this case, Lordship, the issue is, even though Lordship hold that the charges are serious, Lordship, whether the government can dispense with the procedure as laid down in Rule 9 of some discipline and appeal rules, Lordship. The petitioner lordship, he was promoted on 11/7.
Initial recruitment?
Lordship. He was initially recruited, appointed on 10/12/1986 lordship, as the post of LDA in the district fishery office at Nolbray.
LDA in the office of?
District fishery office at Nolbray. Lordship.
Then?
Lordship, then Lordship, in the year 1994, he was transferred in the office of the district fishery office, Kamrup, in the same post as LDA. Lordship. Last promotion, Lordship.
Just a moment, just a moment. District for fishery officer,
Kamrup, in the same post, Lordship.
Kamrup, rural. Where was he posted? What?
Rural.
Where place of posting? Amranga. Then?
Thereafter, on 4th July, he was further transferred to the fishery marketing officer.
Fisher, 4th July 1994.
Yes.
Hmm.
Nakata Pukuri, Panbazar. So, Kamrup district.
To the establishment of the?
Office in the same post, Lordship.
No, no, which office?
Fishery-
Nakatapukuri?
Fishery marketing office.
Do you know where this is?
Nakata, yes, Lordship, Panbazar.
No,
Taomin-
Nakatapukuri, which place it is?
Taomin,
No, no, in the, that is other side. This
Yes.
is opposite to that Chaumi. Here, opposite Don Bosco School.
I am only aware about the Samin, Lordship.
Ah.
Famous Samin.
People know, like what they know, what
Yes,
they
yes.
like. Then what happened?
Thereafter, some some illness was, and thereafter some proceeding was initiated, Lordship, and
Maybe serially.
thereafter the petitioner could not join service from 10/11/2005 to 14/2/2006.
And he was working as at Nakatapukuri at that point of time.
Yes.
2010, 2005 to
2005 to 2009, Lordship.
where?
To-
9 which date?
He was TB, Lordship. He was suffering from TB, Lordship. Two writ petitions were filed, Lordship. That was ultimately
Oh. Writ petition, what happened?
writ petition, Lordship. Ultimately, this honorable court has interfered, Lordship. With that order we
Interfered
have
with
annexed,
what?
we have annexed, Lordship.
Yes, tell me that. Show me that.
Is
28.
20.
So you filed WPC
Two writ petitions.
7797
Two writ petitions.
2005 and WPC
2722 2010. Page 33, Lordship, last 6 line.
just a moment. Okay, after this, what happened?
Lordship, the one disciplinary proceeding was initiated against the petitioner, which culminated into withholding of 3 increments, Lordship, without cumulative effect. That order we have not annexed, but I have that order, Lordship. We have stated in paragraph 5 of the petition, Lordship.
Where is the show cause?
In the instant case, Lordship.
No?
In the instant case,
Huh?
case 64, Lordship.
60?
64.
Affidavit.
A repetition, Lordship.
60?
64. 64. Annex. It is part of the affidavit file in the.
This is the charge sheet against you.
No, Lordship.
Show cause, show cause.
Because this is only supposed in the instant proceeding. Lordship. What happened, Lordship? There
And where is the penalty order?
penalty order, page 52.
No, where is the show cause notice wherein an allegation is that you were absent from duty from 19/9/2019?
No, only this. No. These are the so-called notice. That's why I have initially stated, Lordship, whether the government can dispense with the Rule 9 of the Civil Appeal Rules.
No, no.
66 lot. Of the writ petition.
Huh?
A66 of the writ petition.
Sixty-two, 63 also, 65 also.
Only this much.
Yes, Lord.
Now, what are the periods not regularized? The earlier periods regularized.
That was regularized, Lordship. That was order.
The TB period, everything regularized. Huh?
Yes.
Only this 19 absences.
Yes, Lordship.
So it is in this context that you want to say that you were at that point of time working as that NRC duty.
NRC duty, Lordship.
Page 37.
Page 36, Lordship. Pursuant to the earlier proceeding, Lordship, the petitioner was promoted, Lordship, and posted at research officer Amrongan, page 36. And thereafter the petitioner, page 37. The petitioner was engaged as an NRC officer, Lordship, and duties and responsibilities of BA, Lordship.
So this was from the period which effect from 11/9/2019.
Yes, Lordship. The duties and responsibilities, Lordship. May I read, Lordship? Page 37.
Where is that show cause 63?
65. 64, 65, 66, Lordship. That is supposed. This is the ex parte proceeding, Lordship.
64,
65,
60?
6.
And this led to page 52 order.
Yes, Lordship. And before that, Lordship, one inquiry was held on page 51.
So this is the inquiry report.
Inquiry report. But Lordship may read it, the page 142 of the affidavit in opposition filed by the respondent, Lordship, Fishery Department. The inquiry committee was constituted on 11 August 2020. Page 142, Lordship. Last, Lordship, 11 August 2020. And the inquiry report, 13 August 2020, within 2 days, Lordship.
Madam, what is this? We have not. Mr. Kolta,
Yes, sir.
why such big arguments? Simple case. Come to page 64. Before that, come to page 52.
Yes.
Huh? 52 is action under the Assam Discipline Appeal Rules 1964.
Lordship.
Now, whether any of these show causes can be said to be a show cause under that. What are you writing here, madam? How can you go and take this step?
Lordship,
You come to page 64.
yes, page 64 is
See the
there.
last paragraph.
Yes. Would not be taken in force as negligence of duty. Then Lordship kindly raise the next page
where
also.
where is the
Is
charge
the-
sheet? Show cause. Why
These are-
disciplinary action would not be taken? This
Yes,
is an
Lordship.
explanation call only.
Yes, explanation, but he has not responded to this,
Need not be.
Lordship.
You drop a departmental proceeding against him. We have not drawn up any department.
Then, Lordship, there were paper publications also.
Show me.
Yes, Lordship. Kindly
Show
go
me.
through the pages, Lordship.
Paper publication.
Page
78.
78 onwards.
Where is that?
Page 79, Lordship, on left side. Top bottom, left side bottom, page 79. Then page 80,
No,
Lordship.
79 where it is. This is nothing but.
Then, Lordship, on page 80.
No. This is nothing but in continuance of page 64.
Hmm.
70? 80.
80.
As to why disciplinary, why should you take disciplinary action? Then only you will.
Then 82. Then page 84.
You are wasting government money. Who is this authority?
Then subsequent to 86 and all these, Lordship. But he kept quiet, Lordship. He has never responded to any of this, Lordship.
Now, this notice at page 65 was served on you personally? Nothing.
Lordship, address only
Yes,
stands for-
Lordship, this one we have replied, but he has not replied to that in our affidavit in opposition. Kindly take this.
Okay, whether these notices were served to him personally.
Yes, we have stated these things, Lordship. Affidavit in opposition filed by the
The
respondent
earlier
number 4.
absences cannot be taken into consideration because those have been washed away on his promotion. Gone.
Yes, others we are not on this,
It
Lordship.
is only 2019.
2019, Lordship.
Okay, show me whether this was served on him.
Lordship, 1 minute, Lordship. Lordship, page 129, paragraph 14. The deponent states that since the petitioner had taken away the service books was kept by the petitioner himself, his permanent address was known by the official authority. So the registered port was also not possible to serve the termination order to the petitioner. As such, the research officer Amranga gave newspaper notification, the Sentinel and Akhomya Khobor by giving proper details of the petitioner. Even the official authority has sent the notices to the address mentioned in the service book, but the same was returned back as he was not found there.
You're reading para?
14, Lordship. They have not rebutted,
I
Lordship.
have replied, Lordship. We have filed reply.
Okay, what is your
Can you
reply to
reply?
para?
Paragraph
Reply
14.
back. Reply to-
is 179. That the statement made in paragraph 14 of the affidavit are not correct and as such the same are denied. The respondent stated in one hand, the respondent tried to project that the petitioner has taken his service book and as such registered post was not possible to serve the notices to the petitioner for not having the permanent address. On other hand, they have stated that even the official authority had sent the notice to the address mentioned in the service book, but the same was returned back as he was not found here. The contradictory statement of respondent would clearly show that the so-called inquiry proceeding and the issuance of so-called notice are false, fabricated, and afterthought.
Penalty is?
Dismissal.
We don't have a copy of reply, Lordship.
You have retired already.
2003.
He has retired, Lordship.
2023, March 2020.
Madam, you have not followed the procedure of Rule 9.
Then Lordship, there are also, he has,
Mr. Kolta, give me a small write-up. You have.
One judgment, Lordship, of this honorable court, Lordship. Regarding not for
That is settled position.
by
Why was this not argued last time? It was gone to the BLO part.
yes, Lordship, BLO, that also
No,
we
no,
have
no.
stated,
BLO
Lordship.
part, I was stuck in this case in BLO part. Why did you not take me into this? Or did not allow you to go into that?
And one more thing,
from
Lordship.
paragraph 6 onward, Lordship.
Yes, Lordship, at that time, Lordship may kindly also, okay.
Yeah.
Kindly also peruse page 189, Lordship.
I'm
The
ready to take-
period when he, that means was on duty as BLO, Lordship. That also kindly be considered. Page 189. His
6/1,
period of
2020
appointment,
to
yes,
6/21/3/2020.
yes, and 1/6/2020 to 23/6/2020.
No, I got it. All said and done. There is no proceeding drawn up.
So this
In
is
the
this.
known to the eye of law.
If these were technical
And what
stand,
is
then
this?
that's Lordship.
No, what is this inquiry committee thing going, making an inquiry? Inquiry has to take evidence, witnesses. No witnesses recorded.
I think recorded, Lordship. One more thing.
Paragraph 7 onward, Lordship. Paragraph 6, Rule 9 quoted, Lordship, paragraph 7 onward. Full court judgment of this honorable court was also taken into consideration while passing this.
An explanation call cannot be elevated to the status that maybe your officer did not know of something. When can you give me the write-up?
Before?
No. Before.
So if this type of,
The type of thing is your
Yes,
officers are
Lordship,
facilitating
if-
that, Miss Madam. I'm sorry.
then there will be.
Then what is the use
people
of
with,
9 No, what is the use of 9? Rule 9. Procedure under
Yes.
Rule 9.
That
See,
I
you're
agree,
dealing-
but he knowingly kept silent, and that also
That
the
is his
period of duty he
experience.
rendered there as
That is
yellow,
the
Lordship.
advice given to him by Mr. Kolita. That is why. But that will not save you, because why I'm saying an order of disciplinary proceeding visits him with civil consequences. Once that is there, you will have to follow the procedure. And madam, unfortunately, there is a judgment of this court also. This is not a show cause in the eye of law. Where is the list of documents? Where is the list of witnesses? Where is the statement of allegation? It is only a thing that whether should give me an explanation why I will not draw up department proceeding against you. Rule 9 has not been even thought of there. 3 notices, same thing. And just read the last portion, madam, of those notices. That will clear you. 64, 65, just the last portion, last paragraph. Oh, I was about to crucify him today, but he is safe. Mr. Kolta? When I saw this matter yesterday, I said, oh, BLO matter.
Yes.
We'll.
Otherwise also my starting 2026 if lordship.
Have you got page 64?
Lordship,
Just read the last line, last paragraph,
64.
64. That is the show cause.
These all are show cause.
Okay, read now.
Here only one allegation.
No, read the last paragraph.
Yes, but that this particular section is not mentioned.
No. Read it.
Yeah, so why disciplinary action would not be taken against you for such negligence of duty?
That is enough.
This is there. Then lordship, this will
And mention
keep
your-
going lordship, the
But the Illinois Council for the parties at some length. Hearing remains inconclusive. The Illinois Council for the parties are at liberty to bring on record their arguments, submit their written arguments in the matter on or before 9/1/2026. Registry to list this matter again on by staker action in 28 আছে 29/1/2022. Madam, something very.
but this way.
You know the story of Kesu and Khap.
Because this.
No, you know the story of
President's
Kesu and
lordship and everyone will come and
you know
go.
the story of Kesu and Khap. So if you can bring out a Khap, I am with you. Otherwise, nothing is there.
Keep on continuing lordship.
Huh?
Because these irregularities, they will keep on,
Because
they will
madam, the
keep on
problem
doing
is you
nuisance
know.
lordship and they will come before your lordship and they will be excused for all this
No, I'm
lordship.
not excusing him. I'm only excusing him because I'm only interfering because the procedure is not.
Because he has not even performed his BLO duties also, because this is for a certain period only, but he remained absent for all this long.
When is the allegation of 2019?
Lordship.
And he retired in 2023.
This 2020,
2020 he was dismissed. Dismissal order passed 2020.
Your retirement is 23.
23. 2020 he was dismissed.
So if we interfere with the dismissal order, 24 years within, it will be within 4 years. They can proceed against you. Madam, we have dismissed the appeal, the
this inquiry report.
no, madam.
Oh,
N. Bhattchaji. We have dismissed it. We have asked the trial court to proceed with the matter. So today, 2026 is good. But it is, madam is very angry.
yes. It is bad for me.
What I do?
29th lordship.
You give me that note.
Yes.
If you can give me that note by 29th, no? You can give me that note by 22nd also, no problem. Madam, if you also want to bring me some salient points, you can give me. Any decision, salient points you are there, just give it to me. Thank you.
Hello, please.
Bye.